My lord, the item number 53, my lord, incident is my lord. My lord, in this case, my lord, the IA is for my lord suspension of sentence for release of the appellant, my lord. The sentence is only 4 years, my lord, and more than 1 year he is already in jail, my lord. So my lord, matter may be taken by 2, my lord. Otherwise, my lord, there will be some difficulty. For consideration the IA only, my lord. The
No.
appeal is fixed for hearing in usual course.
Not two. We'll take, if it does not reaches, we'll take it up 330.
Obliged, highly obliged. Highly obliged.
May please your lordship, for listing regular bed of recent 2 days date fixed but not listed lordship. The 2 days 53 days lordship.
What matter?
The lordships, the LDPS lordships.
NDPS senior court is there. You have to mention before the senior. One
The
more,
special is there lordship.
no, one more court is there. You have to
Senior court.
see, mention before senior.
Lordship, item number 3 may be adjourned for 1 week. 3.
Why?
Lordship, I have to obtain some instruction, my lord.
Heard Mr. J. Laskar, learned counsel for the petitioner, who prays for an adjournment on the ground of want of instructions from the petitioner. The prayer is allowed. Let this matter be listed after 2 weeks.
Lordship.
May I please, your lordship? I have experienced number 23, my lord. Here
20.
in this case, my lord, FSL was called for, that has not been received.
Diary received without FSL.
Can it be before vacation, my lord, on 28th,
No, we will see what is the matter when the matter is called.
my lord,
FSL may not be required.
Yes.
my lord. God bless.
May I please, Lordship, I beg to mention item number 36, Lordship. Lordship, city is not there, Lordship.
Yes, 36.
I am on interim, Lordship.
What is not there?
City is not there.
CD is not there.
No, my God, 36.
Heard Miss, what is your name?
M. Decca.
Heard Miss M. Dekar, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for another date for producing the case diary. Prayer is allowed. Let this case be listed again on when?
This is from Sonapur.
I am on interim, Lordship.
Interim is there.
After vacations.
Lordship, another item number 1.
The date sheet over there. 19 July.
Lordship, another one item number 40, Lordship.
Here also diary not received.
40.
Up to the diary was called for, my lord. That is not received. It's from Tezpur.
Same order. Same order.
I am on interim, Lordship.
19 July. Interim shall continue till next day.
Bless, Lordship.
40.
40.
Lordship, Lordship, I beg to mention listing of a bail application, which was listed on 14, but due to paucity of
What is the matter?
bail application, NDPS.
NDPS. NDPS you have to mention before
Put number
senior
20,
court.
21. No, 18.
Lordship, I beg to mention item number 41 to be passed over for after 1.
So diary not received. 41.
Heard Miss
S. Abdullah.
S. Abdullah, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this matter be listed again on
There is no interim, but FOXO notice was issued earlier.
28 June.
Lordship, another item number 45 to be passed over after vacations.
Orders.
Why it has come to on request of learned counsel? No, this is an application file I filed by the state.
Yes, yes.
What is the matter?
Right.
We will take it up when the matter is called. You remain present.
Sorry for indulging again, my lord. 3, my lord, can we post it after 1 week, my lord? From 1st July, there will be holiday, my lord, summer.
Item?
3,
What was the date given?
my lord, after 2 weeks, lordship.
After 1 week.
Lordship. Oblige.
Please, your lordship, I'd like to mention
Item number 3.
item number 35.
Yes.
Pass over for the date.
35, no
Uh,
diary,
Diary is there.
no.
Heard Miss
B does.
B Das, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for
Interim there, my lord.
some more time for producing the case diary. The prayer is allowed. Let this matter be listed on
Interimus.
19/7 for case diary. The interim order shall continue till next day.
Item 54 from supplementary.
Here actually a blunder has been committed. The trial court record has not arrived, which would be necessary for disposing of this case. So as I have heard it, I'll keep it part heard, but I'll call for the case record.
My lord.
Heard Mr. U. Das, learned counsel for the appellant. Also, Mr. D.
This I
Sakya,
can, lord.
learned counsel for the respondent. It appears from record that the case record of NI case number 15/2018 was not called for in this case, which is necessary for
13,
consideration of the instant appeal. Hence, let the case record of NI case number 15/2018 be called for from the Court of Learned SDJM M. Soraidev Sonari. The registry to issue requisition for requisitioning the aforesaid case record. Let this case be listed again on 18 July as a part heard matter.
NI case 13 was probably lord.
There is an overwriting. Is it 13 or
Judgment.
15?
Judgment of 15,
15, okay.
15, my lord.
Is it 13 or 15?
15, my lord,
15,
15.
17 July,
Oblige.
18 July.
Item number 1.
May I please, your lordship. 439 application lordship, petitioner was arrested on 14/5/2024. Today is about 36 days lordship. In this case, from the forwarding report, allegation is that lordship as per FIR.
Why it was rejected?
Court below rejected on lordship, I have mentioned in the paragraph lordship.
Case diary would be required.
Yes.
My lord,
the
but
cyber crime.
before that lordship, at page number 16, 41A notice has not been issued lordship, which is mandatory as per the Honorable Apex Court judgment lordship.
No, but why the matter was brought to the notice of the court before which you filed an bail application earlier, the court below?
It is in the forwarding report lordship. It is page number 16 lordship. It is in the forwarding report lordship.
No, but
Forwarding report itself.
whether the matter was brought to the notice when you filed bail application.
It is not in my knowledge, my lord, but forwarding itself reveal, these documents are before the court below lordship.
Where is the forwarding? No,
Forwarding
I
report at page
think,
16 lordship, first forwarding lordship.
I think case diary would be required even to see.
But lordship, my implication brought on the basis of the statement of one arrested accused lordship as far as FIR.
No, as it has been rejected once, therefore case diary would be required. Heard Miss S K Nargis.
36 that Lordship is from Morigaon Lordship. Can it be on Friday Lordship?
Heard Miss S K Nargis, learned counsel for the petitioner. Also heard Mr. B B Goswami, B B Gogoi,
Gogoi.
learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the same. When can you come?
When will Friday?
27.
27 too late Lordship. We saw because all our section registered this case Lordship. 60 days is mandatory. Already 36 days over Lordship.
27. Let it be on 27. He has to bring the case diary.
It's from Morigaon Lordship, nearest district Lordship.
Let this case be listed.
Morigaon, all right, but it is not that we will go by it.
But because
Our
other person
and
also
bring this,
move
which is
petition.
not-
27.
Alright.
Item two,
It should not, it would, Oh.
I'm
It's a
sure, sir.
439 application, though my lord, the case is registered under the commercial quantity. But lordship, we arrested, petitioner was arrested on 1/3/2024.
When?
Lordship,
When he was arrested?
1/3/2024.
On 1st of March.
First of March, 110 days, lordship, if we go by the
Is that-
FIR, no, lordship, before that, one simple submission is there.
Yes.
Recovery lordship, is about, 42. 32.4636 kg, including the, packets lordship. If we exclude the packets, then it may be 20, kg lordship. A ganja, it is mentioned lordship. It is mentioned in the FIR.
Still, case diary may be required. It may not be commercial quantity.
Yes, lordship.
Still,
But Caesar shows that 23 kg.
oh,
20 season.
okay, then the
3 persons.
statutory period would be over.
Yes, that is right. Can it be
Yes.
lordship on Friday? Lordship? It's from Guwahati lordship. Planet PP can bring that lordship.
PPN आने हैं.
No,
Heard Miss S K Nargis, learned counsel for the petitioner. Also heard Mr. B B Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner Sadiq ul Haq, who has been detained behind the bar since 1/3/2024 in connection with Hathigaon PS case number 39/2024 under section 20B2C/29 of the NDPS Act. Learned counsel for the petitioner has submitted that the petitioner has already been detained behind the bars since last 110 days. However, if the weight of the packets which contain the contraband, that is ganja, is excluded, the seizure of the contraband may come down to the intermediate quantity and hence submits that an early date may be fixed for the case diary. Let the case diary be called for listing, fixing,
25 my lord.
20.
Tuesday next.
Friday lordship, it's from Guwahati lordship.
let it be Friday. Let
Friday.
us see whether it comes up.
Lordship,
Right.
What is
Friday is lordship,
21/6?
Lordship. if you have lordship.
item four,
This is a 439 application lordship, FIR at page 10 lordship. You were arrested on 12/5 lordship, already 38 days lordship. May I read the FIR?
What is the offense? 387.
387 doesn't come, and IT Act section 66 D and 66 E and 67 A. 66 D and E are bailable, 67 A is non-bailable.
First offense is billable.
No, case diary would be required. I have gone through the affair.
Lordship, here Lordship, admittedly, there is a love relationship. What happened, this lady has earlier husband. After coming to know about the said fact, the petitioner refused to marry her. After that, she lost the affair. Lordship, kindly come to the forwarding report, Lordship. At page 14, Lord.
Now, why it was rejected?
Rejected by the learned trial court, Lordship.
Why? Where is the
Lower
rejection?
court,
order?
Lordship.
After perusal of the case
After
diary.
perusal of the case, there, Lordship. Ground of rejection is the sufficient incriminating material against the
No,
accused.
we have to peruse the case diary. Heard, Mr.
Before vacation, Lordship. From Guwahati Court.
Okay. Heard Mr. S. Deka, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary.
On 20,
Fixing
25
25
Monday অলপ অসুবিধা হয়
on 25/6 for case diary.
updates.
Item 55 from supplementary is
Please, Lordship. Lordship, this is the second bail application.
Why
And
it has
DPS
come in?
C,
mo-
status
the
report
case
was
diary-
that not received, my lord.
Lordship, as per my information, he has been received.
Charge matter, my lord, charge matter. Monday দিলে নাহিব পাৰে।
A status report was called for.
Lordship, as per my information, it has been received on 13th of June, but it has not been taken in the record. Lordship. It has not brought to the record.
কালি পঢ়ি লৈলো।
From where you have received that information?
I do not know.
Caribbean district.
No, but
Lordship, may can you be taking it two or
No, two নালাগে, বহুত matter আছে।
then tomorrow?
no status report is there. Then let it come day after tomorrow under
Yes.
bail hearing column. Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. The status report which was called for has arrived.
Time লৈ ল'ম।
You go through the status report.
My lord, my lord. I have not.
Let this matter be listed under
লিখি থোৱা নাই,
hearing,
petition.
bail hearing
No, no, no.
column on 21/6.
Update.
Lordship, item number 2, Lordship, maybe fixed on 27, Lordship, instead of 25.
Item number 427.
Okay. 27.
Mhm.
home motion item 5.
May it please your lordship. My lord, this criminal petition for quashing of the entire proceeding of my lord, this special case number 67/2023, pending in the additional district and session judge, my lord, Kamrup Metro.
What is the ground?
Lordship, may kindly see the FIR. One FIR was lodged by my lord, one Rehman Ali. Page 16 is the FIR, my lord. Alleging that, my lord, this petitioner number 1 and petitioner number 2 got married when she was at the age of, my lord, minor. So this is the FIR filed by one Rehman Ali, my lord. And thereafter, my lord, the petitioner was arrested, my lord, and charge sheet also filed, my lord. And the case was, my lord, the cognizance has been taken also, my lord. And in the, before
framing of the charge, my lord, I filed a petition also for discharge, which was also rejected, my lord. But my contention is that, my lord.
Then you could have
Lordship.
challenged that order.
Petition হয়নি না।
Now, what is your contention?
My lord, my lord, learned court below while going through the record, my lord, charge sheet and other material, my lord, has not considered the case, my lord, for discharge. Because, my lord, from the record, my lord, only witness, my lord, the petitioner number 2, she also joined with this petition, my lord. So, for an material collected, my lord, regarding, my lord, date and age, my lord, she stated that she was.
When the discharge order was passed?
Lordship, may kindly see page,
No, what is your
my
prayer?
lord, page 27. my lord.
What prayer you are seeking in this? What is the relief?
My lord, because, my lord, under fact and circumstances, no case of, my lord, either section 6 of the POCSO Act or, my lord, 376 was attracted.
এই পিটিশনটো ভুল পিটিশন আহিছে, same name, বেলেগ এটা petition আহিছে।
So, at this stage, my lord, lordship may call for the record, my lord, and I have made party the informant also, my lord. Because, my lord, from the evidence part also, and in her 164 statement, my lord, she stated that, my lord, she got married 7 months before, my lord.
No, what is the order of
Lordship, may kindly see page 27, my lord.
date of, what is the date?
2/5/2024.
2024?
2024. Yes, yes.
You could have preferred a revision against the said order.
But I, my lord, for entire proceeding, my lord, because I have.
Entire proceeding, what is the ground? If you are challenging the discharge order,
I also met him in my.
when other relief is available, can you come under 482?
So, lordship may allow me, I will convert it in the revision petition. Or,
You-
lordship,
No, I leave it on you. Whether limitation is still there.
my lord, 2/5. So, revision,
We'll take it up tomorrow. Will you make submission on maintainability of
Yes.
this?
I will. Yes, lordship.
On request of learned Mr. G. Uddin, learned counsel for the petitioner, let this matter be listed again on 26/2024,
26.
tomorrow.
Item 6.
May it please, your lordship. My lord, we are assailing the tenability of the second FIR. Now, if your lordship would kindly come to the first FIR, that is at page 20.
Page
20. And the operative portion is at page 21. With reference to the subject cited above, I would like to inform you that reference above GDE at 5:30 AM information received suspected item inside a polythene bag falling on the roadside at Sangsari NH 31. Accordingly, self along with so-and-so and other staff proceeded at the PO. On being inquired, an opening of the bag found one unidentified female body, aged about so-and-so years old, put inside in a plastic bag. The unidentified woman was found wearing a yellow colored leggings and multicolored top. Executive magistrate arrived at the place of occurrence and inquest was done by him. Videography was done. At the time of investigation, no external injury mark was seen on the body of the deceased. The body was sent to GMCS for postmortem examination. In preliminary inquiry, it is suspected that the woman was kidnapped and killed by unknown culprit in other place and dropped at the highway roadside at Sangsari market near Guwahati Food Express. Fast food shop
to conceal and destroy the evidence. So this is the first FIR, my lord. And the petitioner before lordship, who is an army officer, he was arrested and he was subsequently released on bail also. Now, at this stage, when he was produced before the magistrate, page 22 is the forwarding report. Now, if your lordship will kindly come to page number 24, I'll refer to two paragraphs from wherefrom I'll show, my lord, that even otherwise second affair is not, ought not to have been registered. Please come to para 5 at page 24.
Yes.
The co-accused has confessed, the accused has confessed that he abandoned the girl child at Howrah train station and have been collected, which shows that the accused had taken her to Howrah train station to abandon her. Further, it is also prayed that the arrested accused may be granted 7 days police remand on the following ground: to recover the mobile phone of the victim, for recreation of the crime scene, for thorough interrogation to collect more evidence, to recover clothes of the victim and the girl child, to find out involvement of other accused persons in commission of the crime. Lord, eventually it has turned out in the case that the unidentified body of the woman was the mother of this minor girl child. Now the allegation as it goes that after committing that, he took the girl to Kolkata railway station where he abandoned her. Now the fact that the accused has abandoned the child at Howrah station was within the knowledge of the police authority while forwarding the petitioner before the magistrate. So question of registering a second affair does not arise. Now the second affair, lordship, will come at page number 55 and the relevant portion is at page 58. And most importantly, it is by the same very police station and it's the same IO minor. The operative portion is at page 58. With reference to the above, has the lordship got it?
Yes.
I would like to inform you that as IO of the case during investigation of Sansari PS, number so-and-so under section so-and-so, it has come to light that the accused Lieutenant Colonel Aminder Singh Walia, PRO, Tezpur, had not only murdered the victim Vandana Sri, but also kidnapped her minor daughter, Morusika, aged about so-and-so, from Sansari market. On intervening night of 14th and 15th of February 2023, after murdering Vandana Sri, the accused kidnapped her minor daughter, Morusika, with the intention to conceal and confine her in his official quarter at Chandrapur Enclave, Tezpur up to so-and-so. The minor victim was exploited as she was kept in the official quarter of the accused against her will for days. On 21st of February, the accused shifted the minor victim to Kolkata by flight, again to conceal and confine to avoid police. Then with the intention to exploit the minor girl, the accused took her to Howrah railway station and abandoned her for trafficking. Fortunately, the victim was rescued by the member of NGO before any harm would fall upon her. So, my lord, this is the second affair. Now, what would happen in respect
But this FIR is relating to the kidnapping of the minor girl.
No, my lord, what I'm trying to say is it is the same police station. And while forwarding me, that information was always within the, comprehension of the IO. Now, the question is, while investigating, if this information has come, is it necessary that there should be a second affair? Or he could have added these sections in the first case also. Now, is it the requirement of law? Every time a information regarding cognizable comes to the office, IO, then he will register a fresh case?
No, but in the first case,
Yes.
is there any allegation of kidnapping of the girl child?
But the forwarding report, kindly come to page 24. Para 5, page 24.
Yes.
The accused has also confessed that he abandoned the girl child at Howrah train station and have been collected, which shows the accused had taken her to Howrah station to abandon her. So this information was very much within the knowledge of the IO.
But
The
there is-
instant, no, my lord, my humble submission is as such, the allegations are very serious. There can be no manner of doubt. I'm not on that. Question is, a procedure has been prescribed in the Code of Criminal Procedure. Now, is it not an information which can be construed as an information under Article 162 CRPC? Is it necessary that he has to register a separate case? So kindly see, I'm incorporating in connection with the second case in jail. In the first case, I have already been enlarged on bail. Well, I'll rely on the Supreme Court judgment, one paragraph only.
No,
That-
your submission is that paragraph number 5 at page 25,
Yes,
24
yeah,
reveals an offense.
yes. And he
So
was,
that we have to,
it was within
examine.
the comprehension of the IO. Because that's why he made it very clear. And in fact, he was investigating that. That's why he said, please give police custody of these accused, and which the Honorable Court below has obliged.
now at what stage this second,
No, second case also charge sheet has been filed in both the cases.
two
charge sheet.
separate charge sheets?
Yes. So my humble submission is, my lord, let first case go on, and they can always, at the second charge sheet cannot proceed. The second case has to be stayed. I'm relying on the judgment of the Supreme Court, my lord.
No, before that, you have to convince this court
Yes, yes,
that first FIR discloses an offense.
yes, it does.
But that has to be examined whether because apparently it does not discloses. It
No,
only mentions that the girl child was with him.
No, my lord, my humble submission is whether the first FIR discloses wholly or not, that is not the relevant query. My humble submission, subject to what your lordships may say. In my humble understanding, the law is, as I have gone through the Honorable Court judgment, during investigation of the first case, if information regarding non-cognizable offense emerges.
No, whether it discloses a non-cognizable offense. That was the-
Exactly, that's why he has filed the second FIR. Question is whether he should have gone,
No.
registered the
No,
second
that-
FIR.
That is not my query. My query is while forwarding the accused in the
Yes.
first FIR, while he mentions that
My lord, let me for a moment make one submission. Lordship will not take note of this para 5. Let us, for the present, let us assume this para 5 in the forwarding
Not
report is not there. Let us not go there. Question is, during investigation of the first crime, alleged crime, the IO finds that this accused is not only guilty of murdering the mother, he is also guilty of
committing
kidnapping
another
uh,
offense.
and so for that, is it required that he should, every time he will come register a new case? Can't he add that section in the first thing?
Now, what is the law?
Law is, that's the point. No? Wait.
When it came to his, when the second FIR was lodged,
1 second, my lord. First FIR was lodged within a gap of 1 second. First is 15 to 23.
when the charge sheet was laid,
A charge sheet was laid on, my lord, is 36. It was on 26, 23. And the second FIR, my lord, is of 35/23 before the first charge sheet in the first case. And second charge sheet is dated 60.
now whether is it bad in law
My lord,
if during the investigation of an offense, subsequent offense comes to notice,
yes.
a separate case is registered.
Whether required or it can be done in, law says in my humble understanding that that information should be treated as an information within the meaning of section 162 CRPC, and they should proceed. That's why, my lord, under 173(8), there is a scope for filing supplementary charge sheet. That's the reason. Otherwise, if you look at the scheme of CRPC, that is clearly evident. It's not that if a first charge sheet
No,
is filed.
without adding new,
No, there has to be added. They have to edit, they have to do it, everything. No, they can always add. Now, please have the judgment, my lord. My lord, lordship, we all know about the judgment in T.T. Anthony. T.T. Anthony is quoted in paragraph 13 at page 5. T.T. Anthony, paragraph 13. Then my lord will kindly come to paragraph 17 at page 6. Now the findings in this court. Para 17 at page 6, 3 lines towards the bottom. Thus, in view of the above, law on the subject emerges to the effect that an FIR under section 154 CRPC is a very important document. It is the first information of a cognizable offense recorded by the officer in charge of the police station. It sets the machinery of criminal law in motion, marks the commencement of the investigation, which ends with the formation of an opinion under section 169 or 170 CRPC, as the case may be, and forwarding of a police report under section 173 CRPC. Thus, it is quite possible that more than one piece of information be given to the police officer in charge of a police station in respect of the same incident involving one or more than one cognizable offenses. In such a case, he need not enter every piece of information in the diary. All other information given orally or in writing after commencement of the investigation into the facts mentioned in the first information report will be statements falling under section 162 CRPC. In such a case, the court has to examine the facts and circumstances giving rise to both affairs and test the sameness is to be applied to find out whether both affairs relate to the same incident in respect of the same occurrence or are in regard to incident which are two or more parts of the same transaction. If the answer is in the affirmative, the second affair is liable to be quashed. However, in case contrary is proved, where version in the second affair is different and there in respect of two different incident crime, the second affair is permissible. In case in respect of the same incident, the accused in the first affair comes forward with a different version or counterclaim, investigation of both the affair has to be conducted. So law has been laid down balancing both the rights. My humble submission is, my lord, there's a transaction is one. The transaction is both mother and daughter were flown to Guwahati. Then Guwahati hid this. Then the allegation is she was taken to Calcutta and she was abandoned.
No.
Milord.
How I have not gone through the affair in detail. What I understand.
No, now in the charge sheet, that is the
Now, what from your submission, what I understand is that mother was killed
kill.
and dumped in a gunny bag.
Gunny.
That is one offense.
Yes.
Murder of the mother. And subsequently, after killing the mother, he kidnapped the daughter.
Yes.
That is a subsequent offense. Though mention of the subsequent offense is there in the first affair, some mention. Is there any bar in registering a separate affair?
No.
That is the
No, my lord. That's why I said for a moment, let us not take note of para 5 of the forwarding report. Now the IO is investigating the case. Is it not arising out of the same transaction?
no, but
the same.
it does not relates to same offense. The crime is two different offenses are involved.
No, my lord. Maybe. Question is, what was the bar? Why there was why this subsequent information, why it can't be treated as an information regarding commission of an cognizable offense? To that extent, it's okay. Now, is it necessary that now you
No,
have to
but-
again,
But the para which you have read just now,
yes,
that if the second FIR in
no, are different
are the,
and they're in respect of two different incidents.
here there are two different incidents. First incident relates to murder of the
No,
mother.
Lord, I think with all respect, my submission would be there was a singular act. Singular act of the idea was to kill the mother, going by the allegation, dumping the body in the gunny bag, and also to abandon her in the Calcutta, railway station.
So
No,
that
the idea is one and the same. To
That-
get rid of them.
that has to be examined.
No, so, true, my lord. My only submission is on next day, 19 July is the
We'll
next
call
day.
for the scanned copy of record. This
Yes.
has to be, this has to be examined.
No, my lord,
Whether
that's why,
apparently it is not, there is some area because second FIR in respect of a different offense is not bar, not a bar.
no, my lord, yes, it's not a bar, but if it arises out of the same transaction, that's the law, my lord. For example, if a lordship should just have a look at the para 13 once. Para 13, TT Anthony. Now the quoted portion I'll read. A balance between the fundamental rights of the citizens under Article 19 and 21 of the Constitution and expensive power of police to investigate a cognizable offense has to be struck by the court. There cannot be any controversy that subsection 8 of section 173 CRPC empowers the police to make further investigation, obtain further evidence, and forward a further report or reports to the magistrate. However, sweeping power of investigation that does not warrant subjecting a citizen each time to fresh investigation by police in respect of the same incident, giving rise to one or more cognizable offense consequent upon filing of successive affairs, whether before or after filing of the final report under section 173. It would clearly be beyond the purview of section 154 and 156 CRPC, nay, a case of abuse of statutory power of investigation in a given case. In our view, a case of fresh investigation based on second or successive affair not being a counter case filed in connection with the same or connected cognizable offense alleged to have been committed in course of the same transaction and in respect of which pursuant to the first affair either investigation is underway or final report under has been forwarded to the magistrate may be a fit case for exercise of power under 482 CRPC or under 226(27) of the Constitution. The emphasis is if it is arising out of the same transaction. It is the same transaction. Yes. For example, my lord, if a person, supposing, my lord, initially, my lord, there is a simple heart, then the police starts investigation. Subsequently, the injured person dies.
No, but whether it is same transaction or not, that
Lord.
has to be examined. There is a murder of a woman and subsequently recovery of a girl in abandoned condition from Howrah police station. Howrah,
That information was within their knowledge. Question is, no, my lord, there is no dispute in view of para 5 of the forwarding report that police was aware of the fact that the petitioner is also allegedly guilty of taking the minor girl to the Kolkata railway station and abandoning her. Now, to that extent, the information was within them. Now, the question is to investigate that, whether they are
it's
supposed to
separate.
erase another case
that is,
or they can do in continuation of the same very offense.
yes, that is the question
That is the question.
to be examined.
Yes.
in this. So we will examine that.
My lord, then the lordship will have it before 19th. No?
Okay. Mr.
Or if your lordship is inclined to stay, at least they will not, based on the charge sheet, they will not proceed.
No, I am not inclined.
In that case, lordship will have the matter
Because-
before 19th.
Yes, we may fix it before. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Ms. T. Som,
15th.
learned counsel for the petitioners.
Hmm.
This also had Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Amrinder Singh Walia, praying for quashing of the criminal proceeding.
My lord, with your lordship's kind permission, can I take leave?
Yes, yes,
And my lord will fix it before 19th, on 17th or 18th.
17th, I will.
Well, I'm deeply.
Quashing of a criminal proceeding arising out of FIR number 175/2023 dated 30/5/2023. On the basis of which sessions P case number 129/2023 was registered. Having heard the learned counsel for both the sides, this court is of considered opinion that perusal of the case record of
GR number given.
sessions case number is,
Sessions visits.
120,
it is charge sheeted.
129.
Perusal of the scan copy of this case record of sessions case number 129/2023, as well as the first charge sheet, first sessions case number is
Or belek to sessions number,
as
first case to.
as well as scan copy of the case diaries of Sangsari PS case number 58/2023 and Sangsari PS case number 175/2023 would be necessary. Hence, call for the same from the court of which court it is pending?
I mean, go,
I mean,
just sessions.
station
From the
Aminga.
court of learned sessions judge Amin Gaon. The registry to take steps for requisitioning the aforesaid scan copies from the said court. Issue notice to the respondents. Since the learned additional public prosecutor has received notice for the respondent number 1, no formal notice need to be issued. However, as regards respondent number 2, for respondent number 2 also you are appealing.
Police officer, yes,
You are
we,
appealing.
we may assess.
Since learned additional public prosecutor appears for both the respondents, no formal notice need to be issued. List this case again on 17th of July. 17th of July. In admission column.
Lordship, from my side, one more interim prayer will be considered on that day. That may be added, Lordship.
No, if by going by today's standard. Okay, okay,
It
it
may
will
be
played by,
disposed- It may be disposed of finally after receiving the record.
because today I am not at all convinced. The interim prayers shall be considered on the next date.
And Lordship, first affair is pending at, in the court of additional CGM Aminga. Additional.
No, I have
Commit for
mentioned the numbers.
Obliged, Lordship.
Item 7.
My pleasure, Lordship. My lord, this case relates to the quashing of the entire proceeding, my lord. In the nutshell case is that, my lord, petitioner's son filed a complaint case, my lord, under 138 NI Act, my lord. That was ordered in my favor, my lord. And I, being a father, my lord, I deposed statement, my lord, witness as PW2 in that particular case, my lord. Before coming to that, my lord, the judgment was favor in my son, my lord. That was gone to the appellate authority by the other side. That has been compromised and settled, my lord. Now, my lord, the what happened while passing the in order, my lord, the learned court below, my lord, where is the NI Act was filed, my lord, operative part, lordship will see page 150, only 59, my lord. Page 59 of that judgment, my lord, operative part.
Page para 48, my lord, may I read, my lord? In the instant case, on the examination of the evidence adduced by PW2, Dilip Kumar Chaudhary, that is the petitioner, my lord, ward number so and so, Lakhimpur deposed that he did not contest the election so and so filed in the nomination, but he did not contest the same as he was granted a party ticket. But what appears that the election result is that he contested the said election and obtained 2032 numbers of votes. As the prima facie, it appears that the Dilip Saika had given a false evidence on oath before the court, my lord. Then lordship will see para 50. Para 50. Accordingly, in view of the above discussion, I deem it proper to forward the copy of this judgment to the London Chief Judicial Magistrate for kind necessary action in case of initiation of the proceeding, and judgment may be treated as complaint. Then, my lord, cross, no?
Yes.
Then, my lord, what he deposed before the London trial court, my lord, operative part, lordship can see
To Agor case to Taki.
piece 34, my lord, the cross part, my lord. Operative part, lordship can come to the page 35 directly, my lord. Extreme top, my lord. I had not submitted my income certificate before the court. I was worker of AGP. I submitted my nomination Legislative Assembly in 2016, but I did
Now
not.
you have prayed for quashing of which complaint? Complaint which was registered on the basis of the court's direction.
My lord, court direction, because court direction was that, my lord, it was submitted by the defense side. The then accused, he has given a simple application that I deposed the false application. Basing on that, my lord, the cognizance has taken, and that application was not supported by any affidavit, my lord. And without providing opportunity of hearing, my lord, on that petition, lordship, kindly have a look for a moment, my lord.
Now, what has happened to that judgment where the observation was made?
My lord, trial is going on against me, my lord. Next, today is
No,
the,
no, the judgment has been in page 59.
my lord. 60 is there, my lord. Say,
In page 60,
my lord,
that is,
para 50.
that judgment was passed in a 138 NIACT case, 214/2016.
That original case, it was in my favor. I have received the payment, my lord, in the appellate stage. That has been compromised. Since I have
No, that observation in the judgment was,
in 50, my lord, para 50,
in which judgment that observation was passed?
in an act.
Which
Enact.
judgment?
An act in the very judgment, my lord, in which I was,
Tell me the number of the judgment.
yes, my lord,
Case
that
number.
your lordship will see at page,
CR 2014.
my lord.
Is it CR
My
2014?
lord.
Have you challenged that judgment? Have you challenged that?
No, judgment is in my favor, my lord.
No, but the observation is against.
Observation, now I have come. Now I have come for challenging that judgment.
But you have not challenged that judgment
No, that judgment I did not.
where the adverse observation was
Adverse
passed.
observation was given, my lord. I have filed a petition for their discharging, my lord. I bringing the true facts before the court, my lord. That was been discarded, my lord, which I made an impugnment. As well as, my lord, I have challenged entire proceeding against me, my lord, including that part of judgment. And lordship, kindly have a look, page 4.
Okay, what is your basis?
My basis is that, my
Now
lord,
the The,
lord, I
a-
was the,
let me understand. Now the complaint case under section 193,
138
no, I am on
or
193.
193, my
193, which you are challenging, was filed on the basis of an observation made by the trial court while giving its judgment in a case under 138 NI Act.
lord,
You have not challenged that judgment because that judgment was in your favor,
my lord.
but an adverse observation was there.
My lord, now, my lord, in the way, by way of the revision, my lord, I challenged. My lord. The moment it has affected my right, my lord, I have challenged, my lord. I made a prayer also,
Now, in this criminal petition,
my lord.
what relief you are seeking?
Lordship, kindly have a look at page, my lord. At page 25, my lord, operative part. As to why the impugned judgment dated so and so, complaint case number so and so, the order judgment dated so and so originate from the impugned proceeding in connection with the complaint case number 20140 Chief Judicial Magistrate Guwahati against the petitioner should not be set aside and quashed and call for the entire records of the complaint case number 407 and judgment dated so and so originate from the impugned.
No, you have. Where is the prayer? Set aside and quash.
My lord,
Read the prayer portion.
my lord.
Read. What
From
is your
page
prayer?
25, my lord.
What do you want? Read that portion.
My lord, I made a prayer, my lord, as to why the judgment dated.
No, that was not a prayer. That was the query to the, at the time of issuing notice. What you are seeking from this court?
I am seeking, my lord, particularly, my lord,
Read that portion.
lordship will see the bottom portion, my lord, middle portion. The complaint number in connection with the complaint case from the Court of Chief Judicial Magistrate Guwahati, and after peruse the same, after hearing the parties, your lordship would be pleased to set aside and quash the judgment dated 30/11/19. Initiated against the petitioner in connection with the complaint case number so and so.
Judgment dated 30/11/19
19.
passed in complaint case 2014/16.
16.
You could have preferred an appeal. Now, whether criminal petition lies, 482 petition lies,
My lord, I
when
basically agree,
when
my lord.
statutory relief was available to you.
My lord, there is also no bar, my lord, if there is a. And I was not the, I am not the complainant. My son was the complainant. I'll become a third party there. Because my son,
Then how you can pray for quashing that's
my
setting
lord,
aside
in
that judgment?
respect of the petitioner only, man. In respect of the petitioner.
You can pray only for expunging the adverse remark if
That must remark, and by this time, my lord, they have initiated the proceeding against me, my lord. They have taken cognizance, my lord. Worship, kindly have a look. The cognizance was taken. That was treated as a complaint, my lord. That part I'm coming later, my lord. Lordship, kindly see the page
no, that I have understood.
64, my lord. Page 64, Lordship, kindly have a look, my lord. Having gone through the appointments made in the
Now,
judgment.
why the court was wrong?
My lord, court has misunderstood, my lord. I contested the election. I was a party worker of AGP, my lord, but that was cancelled, my lord. Court subjected a civil case also still going on, my lord. But the question was never put upon me, my lord, that whether I have contested election as a LGP candidate or not.
Records would be necessary.
My lord, till then, my lord, further proceeding be
No,
stayed, my
no,
lord, because
because-
195 lordship is aware, my lord. 195 CRPC says, my lord, how the procedure is to be followed, my lord. But in the instant case, my lord, nothing has been followed. Just, my lord, the judgment cannot be treated as a complaint. Lordship, kindly have a look, my lord.
There was a violation of 195 proceeding.
My
procedure?
195 CRPC was a violation.
Which, what?
That, my lord, violation, lordship will see, lordship is having.
No, what was done in this case and what was not followed, that you have to mention.
My lord, it was, my lord, as per my lord, 195 CRPC, my lord, complainant has to be in writing. Writing, my lord. Writing, 195, lordship, kindly have a look, 195 CRPC, what it says, my lord. Prosecution in a contempt of law, the authority of a public servant or the offense against the public notice for the offense relating to the document given in evidence. No court shall take cognizance of the offense punishable so and so. 192, 195 hobo. Complaint to pass out hobo na. Then my lord, then my lord, lordship will see the prosecution, no court shall take cognizance of any abatement of the attempt to so and so, and this is, and other punishable under these are the law provisions, my lord, section 163, criminal conspiracy.
Which
Then lordship-
provision was violated?
My lord, that I'm coming, my lord, the basic, my lord, the complaint has to be there.
Where, show me.
Yes,
Which
my lord.
provision was violated?
195 followed by 190 subsection 1. What is the complaint about? And the complaint has been defined, my lord, 2D. Whether judgment can be treated as a complaint, my lord, lordship, can you have a look? 2D, what is the complaint about? Two D, my lord, what is the complaint? Lordship, can you have a look, section 2D?
Yes.
What is
No,
the
make
complaint
your
about?
submission.
Complaint means allegation made by orally or in writing to a magistrate with a view to taking action against this court.
That allegation was there in the judgment and there is a
But the,
specific
that the
direction.
judgment cannot be treated as a
Where is the
complaint.
bar?
Judgment cannot be treated as a complaint, my lord.
Where is the bar?
Nowhere it is mentioned, my lord, a judgment also can be treated as a complaint.
But where is the bar when the,
But I'm coming, my lord. Then lordship will see again 190 subsection 1, my lord. What is the complaint about?
then your contentions are to be examined.
My lord, lordship will see, subject to the provision of this chapter, the magistrate, the first class may and the second class so and so specified in the take cognizance of any offense. After receiving a complaint of facts which constitute the offense. That has to be there, my lord. Complaint, what is the meaning of the complaint? It has to be there, my lord.
No. For in your case, only section 195 and perhaps 340 is to be followed. We are calling for the records. You don't have a clear case.
My lord, lordship will see, my lord, for a moment, my lord, why I was being,
Section 340 and 195 are relevant sections.
my lord, I'll come, my lord, that. Lordship will see, my lord, page 70.
Mr. We are issuing notice.
Well, till then, my lord, some protection be
No,
given,
no.
my lord. Or lordship issue a notice on interim prayer on the next. That can be done also.
Heard Mr. J.I. Bordhuya, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under
Nalage,
section
nalage.
482 of the Code of Criminal
Seven pages.
Procedure, read with section 397/401
72 cancel.
of the Code of Criminal Procedure, has been preferred by the petitioner, namely Dilip Kumar Chaudhary, praying for setting aside and quashing the proceedings of complaint case number 4799/2019 under section 193 of the Indian Penal Code, which is pending in the court of, which court it is pending?
My lord. CGM come.
In the Court of Chief, learned Chief Judicial Magistrate, Kamrup Metro,
Metro.
Kamrup Metro. Issue notice to the respondents. Since Learned additional public prosecutor has appeared for respondent number one. No formal notice need to be issued to respondent number one.
Budget particular.
However, as regards respondent number 2, 3, and 4 are concerned, the petitioner shall take steps for issuance of notice to the said respondent by registered post with AD within 3 days from the date of this order, returnable on give a date after vacation. Returnable on 23rd July. Also call for the scanned copy of the case records of CR case number 4799/2019 from the Court of London, Chief Judicial Magistrate, Kamrup Metro.
2014. And that both the cases are to be called.
As well as the case record of complaint case number 2014/2016 from the said court. List accordingly.
One is the main case is disposed of, my lord. NI Act is a
That original may be called for, and the pending case, we are calling for the scan copies.
till then, my lord. Or interim period will be considered on that time, my lord. That observation. On the return of the
The prayer for interim relief would be considered only after service of notice on the respondent,
on the return of the
on the returnable day.
For 38 application lodges, FIR lodges will find page 13. They initially on the basis of information lordship, they received the information that some contraband is there in the house of the petitioner. They received that information and accordingly they proceeded to the place of occurrence. In between lordship in the road, they apprehended one person that your lordship will find page 13 last second paragraph. I along with police party proceeded from TS to Musalpur, Musalmanpara, Panchayat Road, and on arriving we found one male person standing in the roadside and identified himself as Minhaj Ali Sheikh, so Tamarhat Divigar, and caught him red-handed in presence of below noted independent witness. And from him lordship, 4.10 gram of heroin was recovered, brown sugar. And he disclosed that some contraband is there in the rented house of the present petitioner. That your lordship will find page 14 middle portion. Minhaj Ali Sheikh revealed during spot interrogation that he brought the suspected narcotic drugs from Shahjamal Sheikh.
What is your name?
My name is Shahjamal.
Shahjamal. Yes.
That he brought the suspected narcotic drugs from Shahjamal Sheikh, son of so-and-so, village so-and-so, who is living as a tenant. And large quantity of suspected narcotic drugs had been kept concealed by Shahjamal Sheikh in his house. Accordingly, I along with police party proceeded to the house of Shahjamal Sheikh, but he fled away from his house before police party arrived. After reaching, I immediately approached two local people and explained them the situation and requested them to witness the search of the aforementioned house, who agreed to be witnessed. The below mentioned recovered items were also seized by me as per seizure memo in presence of the above mentioned independent local witnesses. The seized suspected narcotics were packed and sealed by me. So subsequently they recovered that number one, your lordship will get 9 small plastic container, that is 37.63 grams of brown sugar.
It was recovered from your residence, your
The rented house where I reside, lordship, they nowhere stated that they broke open the door and they recovered from inside the house.
That will be
It was a
checked by
rented
city,
premise, lordship, the other tenants were also there, lordship.
No, what is your case?
My
No,
case is that.
Case diary would be required.
Quite okay.
Case diary. would be-
37 is not there, that,
No, 37 is not there, but still you have to,
that I leave up to you, lordship.
37 embargo is not there.
It is less than-
Otherwise, how it is recovered? What is your case that I want to know?
My case is that from the FIR itself, your lordship will find that it was recovered from the premise where the accused resides as a teenage, but not from the house. And it is only on the co-accused statement I am apprehending arrest. Lordship. Because nowhere in
diary
the
would be
FIR.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. Considering the nature of allegation leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary,
27.
fixing 27(6) for case diary.
Item 9.
My lord, this is an application under section 438. In this case, my lord, the petitioner is an practicing advocate, my lord. My lord, the fact is like this, my lord. The informant of this case, my lord, her husband and son and daughter instituted a case against the elder brother of the informant's husband, my lord, for a plot of land, ancestral property, my lord, there. And that in the title suit was instituted before the, my lord, the district court, my lord, Kamrup Metro, my lord. But during when the proceeding was going on, my lord, the defendant number one, that is the elder brother of the informant's husband, my lord, he died, and his son and daughter were substituted. Thereafter, both the parties, my lord, executed an agreement for an amount of rupees 17 lakhs, my lord. Kindly see, my lord. Page,
No,
my lord.
no, first let us go through the FIR.
Oh, yes, my lord.
Where is the
It is
FIR?
not, my lord, page 48, my lord.
What is the allegation?
Allegation is that, my lord, the petitioner is the, in fact, my lord, the petitioner is the engaged counsel of the defendant.
Okay.
He asked for money, what is to be the remaining amount of money to pay to the, my lord, his client, my lord. It is also reflected in the, my lord, FIR also. May I read, my lord?
Yes.
I, Rimu Sharma, wife of so-and-so, aged about so-and-so, permanent resident of so-and-so, writing to file a formal complaint against advocate so-and-so, practicing in Guwahati city and to my knowledge in the lower courts. On 18/5/2024 and approximately 12:54 p.m., I received a phone call from advocate so-and-so.
What is this registered agreement?
Agreement for that the compromise between themselves, my lord. That the plot of land will be given by the defendant to the plaintiff, that is to the informant side for a consideration of 17
Who is
lakhs.
the defendant?
Defendant is the, my lord, his name was, my lord, Nipendranath Sharma. He died, my lord, and his wife and son and daughter were substituted, my lord.
And who is the plaintiff?
Plaintiff is the, my lord, the informant, her husband and son and daughter, my lord. I have also annexed the title suit also, my lord.
Where?
It is in page 11, my lord. It is already disposed of, my lord, already withdrawn by both the sides, my lord.
Okay.
Page 12, my lord.
As per amicable settlement.
Yes, yes, my lord.
There-
And it was,
a registered agreement was,
my lord, it was, my lord, it is been page number. Page, my lord, 27. It was executed, register agreement was executed on 5/9/2023 before the sub-register Guwahati.
between the plaintiff and the defendant.
Yes, my lord.
And thereafter now allegation is that
Allegation, my lord, the plaintiff is to give rupees 10 lakhs to the defendant.
okay.
And that too for the treatment of the defendant's wife, my lord. He already died, he's for the treatment of defendant's wife. So when she asked for, my lord, the amount to the informant, she didn't respond. So she requested the petitioner, who is the engaged counsel in the title suit, to request her to pay the amount. When he requested, she was very.
He lost the affair.
She lost the FIR that he demanded the money, but she reflected in the FIR that for her client, for his client. Kindly see, my lord. Page 48, my lord.
Yes, Mr.
You're
Kaushik.
Claiming it was for his client, the
Yes.
FIR it is mentioned.
It is all
What is to be done?
reflected in the FIR, my lord.
That is appear.
Will you appear before I?
Yes, well, I'll appear, my lord.
CD would be required or we can dispose it of.
CD required.
He has already, my lord, visited the police station. The police asked him, the first FIR was lodged before the, my lord, all over police station. He said they called the informant, the petitioner. He visited the police station, showed the documents.
Heard Miss N.S. Thakuria, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Prashanta Goswami, who is apprehending his arrest in connection with Chandmari PS case number 139/2024 under section 384/294/506 of the Indian Penal Code. The gist of accusation in this case is that one, Rimu Sharma, that on which date FIR was lodged?
21/5/2024, she lost the complaint, my lord.
21/5/2024, one Rimu Sharma had lodged the FIR before the Deputy Commissioner of Police within bracket
No,
crime.
first, my lord, before the, my lord, all over police station. It is in page number 48. Page number 48, my lord.
Oh, okay. Before the officer in charge of all women police station, Pan Bajar, inter alia, alleging that on 18/5/2024, the present petitioner had threatened her to threatened her over telephone within bracket mobile to pay the agreed amount in terms of registered agreement bearing number 23190/19350
18350.
18350 dated 5/9/2023
23.
to his clients on register to his client. Learned counsel for the petitioner has. Now, why are you apprehending?
My lord, my name is there, my lord. I have made demand.
Learned counsel for the petitioner has submitted that the present petitioner is a practicing advocate and was the engaged counsel
Counsel.
for plaintiff or defendant?
Defendant.
For engaged counsel for the defendants in title suit number 1 of 2021, namely Shri Nipendra Nath Sharma and his wife and son,
Yes, son and daughter.
son and daughter. The said, it is submitted by learned counsel for the petitioner that the said title suit was compromise between the parties, and in terms of compromise, a deed of agreement was executed between the plaintiff and defendant on 5/9/2023, wherein the Plaintiff was to pay.
Plenty was to pay, my lord.
Plaintiff was to pay
Yes, 33, it was
an amount of rupees 10 lakhs,
17 lakhs,
17
out of
lakhs,
which 7 lakhs were given. me.
an amount of rupees 17 lakhs to the wife of the
Dependent number,
defendant number one
yes,
for her treatment.
treatment.
It is also submitted by learned counsel for the petitioner that out of the said amount of 17 lakhs, the plaintiff had already paid
7
an
lakhs.
amount of rupees 7 lakhs. However, the outstanding amount of rupees 10 lakhs was not paid. And it was on the request of his client, that is the wife of
Nipendranath Sharma.
Nipendranath Sharma, the petitioner had requested the informant over telephone to pay the outstanding amount.
Yes.
However, instead of paying the outstanding amount, the informant has lodged the false FIR against him. It is also submitted by learned counsel for the petitioner that the allegations made in the FIR against the present petitioner are not true, and he is ready to cooperate in his investigation. However, he is apprehending arrest in the instant case. Stop. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing after vacation.
19 July.
Fixing 19 July. Fixing 19 July for case diary. However, in the meanwhile, considering the nature of allegation level in the FIR, as well as facts revealed from the documents annexed with the bail application, as well as the submissions made by learned counsel for the petitioner, the petitioner, the above named petitioner is directed to appear before the investigating officer of Chandmari PS case number 139/2024 within a period of 10 days from the date of this order and cooperate with in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Chandmari PS case number 139/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to following conditions. Condition number 1 and 2. Let this case be listed again on 19 July 2020.
Deeply obliged by me.
Let's
Yes.
start, Your Honor, please. Your Honor, this is an application number 438 of CRPC. The LS sections are 380 of IPC
Where is
and
the FIR?
13(1)
FIR,
FIR at page 8, Your Honor.
page 8.
8.
Who are you?
I am Sahidul Islam, Your Honor.
How you are connected with this case?
Your Honor, in the FIR, there is no name. Actually, the informant has written that his cows were stolen or it was missing from his cow shed along with some other persons. Now, Your Honor, during the investigation by the police, they have arrested one Maqbul Hussain on 25/5/2004, Your Honor, which is reflected in page number 10, Your Honor. Page number 10 in the forwarding report by the police
to that Maqbul Hussain in a relevant portion at ground of arrest, serial number 1. They have mentioned the name of Shahidul Islam of Kabaitari on the basis of the interrogation and statement of the arrested person, Maqbul Hussain, Your Honor.
You are Shahidul Islam, not of Kobaitari. You are also Shahidul Islam of Kobaitari.
Kabaitari, Your Honor. I am
He
Shahidul
is the
Islam.
Shahidul Islam of Kovetari, and that in the FIR it is Shahidul Islam of Helupara. His
Different.
cow has been stolen. FIR named Shahidul Islam, and this and forwarding report this
No,
is the accused.
Shahidul Islam is also the informant.
Yes, madam. One of the
informants.
one of the victim actually, madam.
Victim.
One of the victims.
And you are the
Shahidul
the
Islam.
Shahidul Islam of Kobaitari.
Kabaitari.
So your name is there.
Yes.
In the police forwarding report, my name has been stated by the police on the basis of that some telephone call was in between the arrested person and the Shahidul Islam was they have traced out
CD will be required, madam.
CDR. So CDR system, Your Honor. But on the basis of that only, my name has been, I am suspected and I am apprehending the arrest, Your Honor. I am ready to cooperate with the investigating authority, Your Honor.
Yes, Mr. Kochik.
Madam, here CD will be required, madam. Because there seems to be clear nexus between the accused person, madam. And these are organized crime.
No interim.
I may be here. Because.
Let us fix a short date. Where is the case diary?
On 28.
We are fixing it.
Until maybe. Granted, Your Honor. There is no prima facie case against me.
There is prima facie case, madam.
Let us see. Heard Mr.
SN.
S.N. Nath, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. Considering the materials available on record, that is the allegation made in the FIR as well as the forwarding report dated 18/5/2024. The perusal of the case diary is felt necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Fixing. Give a short date. 28.
Madam.
Fixing 28 for case diary.
May please, Your Lordship, I deeply apologize. I am interrupting in between. In item number 4, initially the date was fixed on 25/6. Then thereafter, my senior said that can it be on 27/6. After going through a diary, we came to that we have an outstation case on 27. Can it be on 25 itself, 25/6 for case diary, Your Lordship?
No, you check your diary properly
Yes, Your Lordship.
and then come at 2.
Yes, Your Lordship.
Because we apprehend that you may again appear at
No,
2.
no, we have checked. Can it be on 25?
Okay, 25.
I'm
I'm taking a
deeply-
short break.
Deeply obliged.
Item 11.
May I please, Your Lordship? 438 application, Your Lordship, FIR at page number 10, Your Lordship. There are two petitioners, Your Lordship. And the allegation is that, Your Lordship, total 10 numbers of bulls has been loaded in a vehicle, Your Lordship, in a cruel manner. And at the time of interception, Your Lordship, by one SI Lordship, Bimal Singh Dera, Your Lordship, the driver and conductor, Your Lordship, failed to produce relevant documents, Your Lordship. And for that, Your Lordship, 379, Your Lordship, of ITC, Your Lordship, and section, Your Lordship, 13(1) of the Cadet Preservation Act and 11(1)(a)(b) of the Prevention of Cruelty Act has been booked, Your Lordship, in this FIR. Though my name is not there, Your Lordship, petitioner number 1 is the registered owner of the vehicle, Your Lordship. And the petitioner number 2, Your Lordship, the rightful purchaser of those bulls, Your Lordship. And to prove my, Your Lordship, this avowance in my bail petition, Your Lordship, I have annexed some receipt, Your Lordship, the purchase receipt, Your Lordship, of those 10 numbers of bulls, Your Lordship. That is at page number, start from page number 14, Your Lordship. That is a typing copy of those receipt, Your Lordship. Because purchase from Your Lordship, Bihara Weekly Market, Your Lordship. There's an open market, Your Lordship, at Golaghat, Your Lordship. It was purchased from that market, Your Lordship.
My lord, he has annexed some receipt here in my lord. That if you can submit those
Heard
before the
me.
IO, my lord.
G. Bora, learned counsel for the petitioner. Also heard Mr. R. Kaushik.
My lord, these receipts are pertaining to Hanifa Ali. Petitioner number 1 is
Petitioner number 1 is the owner of the vehicle.
vehicle.
Because RC is also the Lordship.
Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Mukleshur Rahman and number 2, Hanifa Ali, who are apprehending their arrest in connection with Jagi Road PS case number 105/2024 under section 379 of the Indian Penal Code, read with section 11 within bracket 1 within bracket a within bracket small b of the Prevention of Cruelty to Animals Act 1960 and section 13 within bracket 1 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 30/5/2024, one Bimal Singh Dera, SI of Police of Jagi Road Police Station, had lodged an FIR before the officer in charge of Jagi Road Police Station, inter alia, alleging that on 29/5/2024, one Mahindra Bolero pickup vehicle bearing registration number AS02DC2191 was intercepted at Goa village near water factory, near water factory. And on checking of the said vehicle, it was found that it was carrying 10 numbers of bulls in a very congested and cruel manner. During interrogation, the driver of the said vehicle, namely Ms. Dinar Hussain, failed to show any valid document regarding carrying of the said bulls, and therefore it was suspected that the said bulls were stolen bulls. Accordingly, on receipt of the said FIR, Jagi Road PS case number 105/2024 was registered. Learned counsel for the petitioners has submitted that the petitioners are no way involved in the offense alleged in the FIR, as the petitioner number 2 is the owner of the bulls which were seized in this case, and in support of said contention, learned counsel for the petitioner has produced some cash memos in the name of the petitioner number 2, which were issued by Golaghat Jilla Parishad Bihora Weekly Cattle, Buffalo Sale Market, Bokaghat. Learned counsel for the petitioner has also submitted that the petitioner number 1 is the registered owner of the seized vehicle, and in support of her submission, he has produced the a copy of registration certificate of the seized vehicle. Learned counsel for the petitioner has also submitted that the petitioners are ready to cooperate in the investigation. However, they are apprehending their arrest in this case. What is to be done? Dispose of or case diary?
The case diary, my lord. Let them
Learned,
submit the document before the IO.
learned addition. Learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Fixing
24th July.
24 July for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner and as well as considering the documents produced by her in support of her submissions, the above named petitioners are hereby directed to appear before the investigating officer of Jagirod PS case number 105/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Jagirod PS case number 105/2024, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 24 July.
Much obliged.
Madam Clerk,
May please, my lord. This is a 438 application, my lord. FIR is page 16. My lord. Allegation is that, my lord, I have taken 53 lakhs for financial help from the informant, my lord. And he alleged that I am helping the supplying vehicle of Oil India Limited, my lord. That is, my lord, allegation, my lord. And my lord, another thing is, my lord, before that.
What is the allegation? You took 53 lakhs
Yes.
loan.
Yes.
Loan.
Yes.
And then?
Then, my lord, then, my lord, he filed an FIR before that, my lord. Page 22, my lord.
You are against this FIR?
Yes, my lord. In page 22, there is another FIR which was earlier filed, my lord, than this, my lord, and I have granted bail, my lord. Then, my lord, when I have granted bail by this honorable, then, my lord, this FIR filed. And NIA.
Bail or anticipatory bail?
Yes.
In page 22, you were arrested?
Not, my lord, anticipated.
Anticipated
Yes,
bail.
my lord. Page 24 is, my lord, order, my lord.
Now,
Same-
what is the allegation in the same allegation?
Yes, same allegation, but my lord, that supplying hands to me in supplying vehicle to Oil India Limited, Duliajan by projecting himself as a first class contractor and a regular supplier of vehicle.
Okay, similar.
Yes. Page 22 also, my lord, there is nothing for, my lord, they develop story, my lord.
Now, what is their story? You took 53 lakhs.
Yes, my lord.
What was the assurance given by you?
I will repay, my lord.
And apart from that,
Yes, my lord.
any
Nothing.
other assurance?
No, my lord, this is allegation, my lord. Main fact is, my lord, at page 22, my lord, which is filed in earlier, my lord, by the same informant. I have paid 11 lakhs also, my lord. There is a, my lord, money receipt, and my lord, check was bounced, that is, NI case was also going on regarding this.
That 11 lakh was bounced.
Yes, that was bounced, my lord, NXR 4, my lord, NI case was going, I will pay, my lord, for financial hardship, I could not pay, my lord, whole amount. My lord. That is the case, my lord.
Similar case, earlier he was granted bail.
It seems, my lord, both FIR are almost same.
Same FIR. Heard Mr. M. Kolita, learned counsel for the petitioner, also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Dr. Rajiv Kumar Mohota, who is apprehending his arrest in connection with Dibrugarh PS case number 210/2024 under section 406/420/468/471 of the Indian Penal Code. The gist of accusation in this case is that on 1/6/2024, one Ranjan Gogoi had lodged an FIR before the officer in charge of Dibrugarh Police Station, inter alia, alleging that the present petitioner had taken a loan of rupees 53 lakhs from the first informant with a promise to repay the same and or to provide his help in supplying the vehicles to Oil India Limited by projecting himself as a first-class contractor. However, it is alleged that the petitioner had issued 3 checks to the informant, which were dishonored by the bank on the ground of insufficient funds. And accordingly, the informant had also instituted criminal case against the petitioner under section 138 of the NI Act. The informant has made allegations of forgery and manipulation against the present petitioner in the said FIR. Stop. On receipt of the said FIR, Dibrugarh PS case number 210/2024 was registered. Learned counsel for the petitioner has submitted that before lodging the FIR, the said FIR on 1/6/2024, the informant, Shri Ranjan Gogoi, had lodged an FIR earlier on 16/1/2024. 16/1/2024 on similar grounds and on similar facts wherein the allegation of taking loan of rupees 53 lakhs by the present petitioner was made. It is submitted by learned counsel for the petitioner that in the said case, now, after lodging of the first FIR, Dibrugarh PS case number 21/2024 was registered. And in the said case, apprehending his arrest, the petitioner approached this court and a coordinate bench of this court had granted a anticipatory bail to the petitioner by granted, it has become final.
Yes.
Granted anticipatory bail to the petitioner. Learned counsel for the petitioner has submitted that as the petitioner has obtained the bail in the first FIR filed by the informant, the informant has filed the second FIR on the same grounds. It is also submitted that the dispute between the parties are civil in nature and the petitioner due to his financial constraint was unable to repay back the loan. However, he is willing to
Yes.
repay his loan. It is also submitted that the petitioner is willing to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary, fixing
24 July.
24 July for case diary. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as considering the materials available on record, the above named petitioner is directed to appear before the investigating officer of Dibrugarh PS case number 210/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Dibrugarh PS case number 210/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 24 July.
Bless.
Item number 17.
So again, Lordship in consideration. So Lordship में in the last occasion, Lordship was asking for another month to wait. So Lordship may post it on 28th Lordship.
After vacation,
No, 28th Lordship.
will you be completing?
Yes, Lordship.
What is the progress of the investigation?
And the stall only, same only.
No progress.
No progress, Lordship.
Only one PW examine, madam.
Only within
That
almost
is
1 year,
forensic expert.
only one exam.
On request of Ms. T. from learned counsel for the petitioner, let this matter be listed on 28th July,
No,
June.
Lordship, June.
28th June 2024.
May I please your lordship? 439 application lordship. Petitioner was arrested on lordship. 19/7/2022. Today is about 1 year, 11 months. And charge sheet submitted on 30th September 2022 and charge claim on 25th January 2023.
Charges on 27.
25 January 2023. And since then, till today, Lordship, the 6 witnesses cited in the charge sheet. But since then, till today, Lordship, since 25th January 2023, till today, no witnesses examined yet, Lordship. And there was a direction from this Honorable Court, where while he approached before this Honorable Court, second time, this Honorable Court passed a direction, Lordship, to make a calendar for exam at page 27, Lords, you will find. Last paragraph, Lordship. In the last paragraph, it is directed by this court for fixing the calendar of hearing of the all dates, so that these 6 witnesses could be examined, Lordship. This direction was passed on 26/6/2023 in BA number 1695. Thereafter, a bail petition moved before the trial court, citing all these reasons, Lordship. But even after that, the trial court rejected the bail petition without giving any reason regarding the calendar of the hearing, Lordship. So now he has completed, though recovery was from a truck.
Where it is mentioned calendar?
Calendar is at page 27, second paragraph, Lordship. Last line. Is the order of this Honorable Court. Lordship got it. Last line, Lordship. If deemed necessary, fix a calendar of hearing. After that, the petition moved before the trial court on 30/11/2023. The petition was rejected by the trial court, but without citing any reason for not making any calendar of hearing. And Lordship, since then till today, though it is rejected on 30/11/2023, till today, no witnesses examined by the trial court. And Lordship, in this case, the recovery from the truck, they were the driver and handyman.
What was the recovery?
The recovery is the cough syrup bottles. Is the message anything?
What is the recovery?
Recovery, Lordship, Caesar list, Lordship will find at page number 19.
Where is the FIR?
FIR is at page number, Lordship will find at page number 13. It start from 13 also. But Lordship will find at relevant portion at page 18. Page 18. May I read, Lordship?
No, how much cough syrup was seized?
Cough syrup bottle was, Lordship, 139 cartons. Each cartons containing 12 syrup box. Each box containing 12. Total, Lordship, 20,016 numbers from a truck, and a truck given in custody, Lordship, to the owner, Jimma, Lordship. Then they, without the trial, they are inside the jail, Lordship. And reason for delaying this, Lordship, nowhere mentioned by the trial court as to why they could not be examined these witnesses. or that lordship acts itself, lordship, earlier also in so many cases we argue before this honorable court regarding 36 of this under this act, because the court constitute only because of that reason, lordship.
What
Spirit-
judgments are you relying?
Your lordship judgment.
Earlier judgments.
Your lordship judgment, one judgment, lordship. Okay. This is Sumit Thar lordship. It is your lordship granted bail in 1 year, 7 months. Your lordship granted this bail, and other lordship is 1 year, 10 months granted bail in this case, lordship, and other also I'll place lordship. Other Thana Singh and Husainara Khatun, all this I'll place lordship. I'll rely all this lordship. Because of this section 36(1), speedy trial is essential under this special act. That is why this act, these courts are constituted.
You have that judgment?
Yes.
Give me. Yes, Mr. Kaushik.
Well, so far, the order passed in the earlier bail application is concerned, no? Page 27. That is a suggestion, that was not a
That was
direction.
not mandatory.
That was not mandatory. It was specifically mentioned if
But
our bail
but the
application is filed.
prosecution side has failed to examine even a single witness.
My lord, so far that thing is concerned, my lord, I have checked from 22/8/23, 22/8/23, 22/9/23, 15/9/23, 29/9/23, 5/10/23, 9/10/23, 12/10/23, PO transferred. That is reflected in the order.
Thereafter also,
That is in the
thereafter
order.
no witnesses.
And so far, my lord, after that, yes, my lord, there was no witnesses present in law. On 2 occasions, they also took time, the accused person there, their counsel was not present.
No witnesses came, lordship. So question of taking the adjournment by the side of the
No,
defense.
I am saying on the record only. my lord.
Okay,
Now,
on
the record only.
22, from 22/8/23
Three.
till
12/10/23,
12/10/23, there was no presiding officer.
PO is transferred, that is reflected in the order.
Okay.
22/8/23 to 12/10/23.
But lordship, charge frame on 25th January 2023.
So far, that prolonged thing is concerned, my lord. Because these are the commercial quantity, my lord, and there is no, my lord, prolonged incarceration, my lord, from 25/1/23, because nowhere Supreme Court has fixed a particular period that this period should be considered as a prolonged incarceration period, my lord. In fact, my lord, Mohit Agarwal case also, in para 18, it was specifically mentioned that a period of detention, all these things will not be counted while dealing with a commercial quantity, my lord. And that judgment is still prevailing. That was not been assailed. Mohit Agarwal case, my lord.
Where, show me that,
I'll place, my lord, Mohit Agarwal case, my lord.
which provision, because there are other judgments.
There are other judgments, but Mohit Agarwal is also prevailing because that was not assailed till now. my lord.
No, which will prevail.
There are conflicting judgments, right?
Regarding Mohit Agarwal also, my submission is that regarding Mohit Agarwal already in length lordship discussed in earlier judgments. I'll place that. The lordship Mohit Agarwal itself help us indirectly.
There are coordinate bench judgment here, my lord. Rakibuddin case is also there, and T. Ramu, that is not in a NDPS case, that where it has been mentioned that, my lord, a heinous offense or bail should not be granted, my lord. Although that was passed in an anticipatory bail application, my lord. And so far, my lord, parity is concerned, my lord. Maybe, my lord, some cases, some judgments were passed. And that cannot be, the benefit of that cannot be taken, my lord.
We are not seeking bail on parity, lordship, in this case. Lordship, after pass so many orders.
I heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. this application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely Muhammad Naushad, number 1, and Muhammad Mogish, number 2, who are detained behind the bars since 19/7/2022, within bracket, for more than 1 year, 11 months, bracket close, in connection with NDPS, NDPS case number 221/22, arising out of Gorsuk PS case number 219/22 under section 22C/29 of the NDPS Act, 1985, which is pending before the Court of Learned Additional Sessions Judge number 3 within bracket FTC, Kamrup Metro, Guwahati. The gist of acquisition in this case is that on 18 July 2022, one Sri Karthik Basak, SI of Police of Gorsuk Police Station, had lodged an FIR. You may take your seat.
Hello, I would like to point out one thing also. These petitioners are not from Assam, they are from Uttar Pradesh. There is a flight risk.
Okay.
They are not, yes, madam. Because while considering bail, that is one of the important factor, madam, along with the gravity of offense.
But where there is flight tricks, you have to be fast. By citing flight tricks, you cannot sit over the cases.
Yes, that is true.
What was the? Lodged an FIR before the officer in charge of Gorsuk Police Station, inter alia, alleging that on receipt of an information through reliable sources, that vehicle bearing registration number UP-21-BN-8713 carrying huge quantity of contraband within bracket cough syrups was coming from Jalukbari towards the Imphal side, towards Imphal, and a Naka checking was conducted. At Lokhara near Lalumgaon. Stop. On the said day at about 11:10 a.m., the vehicle bearing the aforesaid vehicle was intercepted and during search of the said vehicle, 139 numbers of cartons containing 12 syrup boxes, each box containing 12 numbers of bottles of, within inverted comma, NREX CP, chloramphenyramine maleate and codeine phosphate cough syrup, within bracket, in total 20,016 bottles of cough syrup were recovered therefrom. On receipt of the said FIR, Gorsuk PS case number 219/2022 was registered under section 22C/29 of the NDPS Act 1985, and the investigation was initiated. On completion of the investigation, where is the charge sheet?
Charge sheet I have an exclusive,
Yes.
page number 37. Original will. Vernacular is at page 39.
Yes. Charge sheet was laid against only two.
Two.
On receipt, on completion of the, on receipt of the said FIR, investigation was initiated. And ultimately, on completion of the investigation, charge sheet was laid against the petitioners, against the above named petitioners under section 22C/29 of the NDPS Act. The charge sheet was laid on 30/9/2022, and 6 numbers of prosecution witnesses were listed in the charge sheet. It is pertinent to mention herein that since the date of arrest, that is on 19/7/22, the petitioners are detained behind the bars. Learned counsel for the petitioner has submitted that even after lapse of 1 year, 11, submitted that the charges were framed against the present petitioners on 25/1/2023, and thereafter, even after lapse of 1 year, 11 months of the detention period of the present petitioners, the trial in this case has not progressed. Learned counsel for the petitioners has also submitted that prior to approaching this court by filing the instant bail application on earlier 2 occasions, also the petitioner had approached this court and the prayer for bail was rejected on those occasions. It is submitted by learned counsel for the petitioner that while disposing of the second bail application of the present petitioner, a coordinate bench of this court by order dated 26/6/2023 passed in bail application number 1695/2023 had observed that the trial court shall make all endeavor to expedite the trial of the petitioners to ensure speedy justice to them, and if necessary, by fixing a calendar of the hearing. It was also observed that the petitioners shall be at liberty to move a fresh bail application before the trial court at an appropriate stage of trial. And if such an bail application is filed, the same should be disposed of and considered in accordance with law. learned counsel for the petitioner has submitted that in spite of categorical observations made by this court, made by coordinate bench of this court, as aforesaid, the trial court had failed to fix any calendar of trial, and even until today, not even a single witness has been examined. It is also submitted by learned counsel for the petitioner that citing all these facts, the petitioner had moved an application for bail before the trial court. However, by order dated 30/11/2023, learned trial court rejected the said application without discussing therein the observations made by the coordinate bench of this court. Learned learned counsel for the petitioner has submitted that though in this case, the charges, though in this case, commercial quantity of contraband was seized and the charge was framed under section 20B2C/29 of the NDPS Act, 1985. However, the petitioners have been detained behind the bars for last 1 year, 11 months, and not even a single witness, prosecution witness has been examined till now. And there is no hope of culmination of the trial at the earliest. Therefore, she has submitted that the petitioner solely petitioners are entitled to get bail solely on the ground of prolonged incarceration. Petitioners are the drivers or what?
Drivers and handymen.
It is also submitted by learned counsel for the petitioner that the petitioners are the drivers and handymen of the seized truck respectively. And in the meanwhile, the seized truck has already been given in custody to its owner. Then quote from bail application number 388123, quote para 8, 9, 8 and 9. Some corrections are to be made. Period of detention bail accordingly. On the other hand, Mr. R. Kaushik, learned counsel for the learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioners on the ground that this case involves commercial quantity of contraband and huge quantity of codeine phosphate was recovered from the truck which was driven by the present petitioners. And the said contraband was found in the conscious possession of the above named petitioner. He has submitted that as commercial quantity of contraband is involved in this case, hence the embargo of section 37 of the NDPS Act 1985 is applicable in the instant case. And therefore, he has opposed the grant of bail to the above named petitioners. Learned additional public prosecutor also submits that since both the above named petitioners hails from Uttar Pradesh, there is also a flight risk once if they are granted bail, and it would be difficult to ensure their presence in the trial. Learned counsel for the learned additional public prosecutor citing the ruling of
Mohit Agarwal.
Mohit Agarwal itu
NCB versus Mohit Agarwal.
NCB versus Mohit Agarwal has, and any other case?
I know one is Rakubuddin. I think Rakubuddin versus State of Assam.
You give in a slip,
Yes, I will give in a slip. Right?
has submitted that in a case involving heinous offense, court should be reluctant to grant bail.
And I have also submitted that matter from 22/8 to 12/10/23.
Yes, itu madhab didi ko korba. Before that, learned additional public prosecutor has also submitted that the court in which the special NDPS case was, special NDPS case number 221/22 is pending, was vacant from 22/8/2023 till 12/10/2023, which has added to which is also one of the cause of the delay caused in progress of the trial, which was beyond the control of the prosecution side. I have considered the submissions made by learned counsel for both the sides, and as well as peruse the scanned copy of the case record of NDPS case number 221/2022, along with the case diary along with the connected scanned copy of the connected case diary. It appears from record that since the date of the arrest of the above named petitioners, that is since 19/7/2022, both the petitioners are detained behind the bars and However, till date, not even a single prosecution witness has been examined. Court para 17 from the Court para 18, 19. 20, 21, 22, 23, 24. Next, in the instant case also, the present petitioners are detained behind the bars for last 1 year, 11 months, or more than 1 year, 11 months. And the prosecution side is yet to start examining its witness. And under such circumstances, and view of the observations made by the apex court discussed herein above, where it has dealt with the question of long incarceration of similarly situated persons who were before the apex court, this court is of considered opinion that in the instant case also, under the facts and circumstances discussed herein above, long incarceration of, the detention of the present petitioners for 1 year, 11 months is long enough. And in considered opinion of this court, it outweighs the embargo of section 37 of the NDPS Act, 1985. And therefore, the petitioners are entitled to get bail on the ground of prolonged incarceration only. What should be the conditions?
My lord, strict conditions of enforcement. Local security.
Will you ensure their appearance?
Yes,
They will,
100%. In all cases.
how much? Tell me the
Amount.
And lordship. Local COT, my lord.
whether such truck drivers are appearing after
Yes,
getting bail.
Lordship, in all cases in which Lordship granted bail, all are appearing notes from Delhi, UP, Bihar, in even Manipur also.
They are
Restricted area, Lordship, from there they are coming.
In view of above, the petitioners, namely so and so, 1 and 2, are allowed to go on bail of rupees 1 lakh each, with 2 sureties of like amount, one of whom should be a resident of within the state of Assam, subject to satisfaction of learned additional session judge
Number
3
3.
within bracket FTC Kamrup Metro, Guwahati. Other conditions same from the case.
Only this Aadhaar card and ID card.
Okay. Condition number 4. The condition number 4 should be the petitioners shall provide their contact details, including the photocopies of Aadhaar card or driving license or PAN card and mobile number and other contact details before the trial court. With above observation, this bail application is hereby disposed.
My lord, my learned friend has realized this Muhammad Raghuvuddin number is BA number 724. Raghuvuddin versus Union of India. BA number 7, 2024.
Date of
Order dated 29/1/2024. Other Mohita girl is there. Obliged.
author. Two minutes are there. Any, sir, any? Yes.
I would like to mention item number 58. My senior English counsel, Mr. K. Singh, is suffering from fever. So, Lordship may kindly adjourn this matter for today. 58. Supplementary.
Heard Miss, what is your name?
M. Devi,
Heard Miss N. Devi,
M.
Learned M. Devi,
Devi,
Learned Counsel for the 50,
8, supplementary, 5-8.
Learned Counsel for the petitioner has prayed for an adjournment due to personal difficulty of the conducting counsel, Mr. K. Sinha. Considering the submissions made by learned counsel, the prayer is allowed. CD is there?
No, my lord.
Prayer CD. On the other hand, learned additional public prosecutor has prayed for some more time for producing the case diary. The prayer is accordingly allowed. Let this case be listed again on
After vacation. After vacation, any day.
on 23rd July.
Page 15.
56.
56, my lord.
56, what this IA is for?
IA is for, my lord, for bring on record and compromise agreement have been to informant and the petitioners, my lord. That's half of the amount has been already been paid, my lord. If your lordship peruse the affidavit filed by the informant, my lord, on 15/6/2024 is flag X, my lord. This is the affidavit shown by.
Where is the affidavit? In IA? Or
Maybe, my lord, in the main file, my lord. Flag X. The lordship got it.
Okay, what is the case actually?
Case is, my lord, the allegation is that, my lord, I have collected some money, the all three petitioners, my lord, both the items, in promising, my lord.
Go one by one.
One by one. In 56, my lord, your lordship will find the FIR at page 15, my lord. It says that, page 15, may I read, my lord?
Yes, what it says.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে উক্ত দ্বিতীয় পদকীয়াজনে মোক কস্তুৰীবাই বালিকা বিদ্যালয়ত পিয়নৰ চাকৰি দিম বুলি কৈ মোৰ পৰা 2018 চনত 2 লাখ টকা লয় আৰু মোক এখন ভুৱা জয়নিং লেটাৰ প্ৰদান কৰে। প্ৰথম পদকীয়াই মোক চাকৰি দিম বুলি মোৰ পৰা প্ৰায় 1,50,000 টকা নিয়ে। উক্ত পদকীয়াজনে একেলগে লগ হৈ মোক বিভিন্ন স্থানত চাকৰি দিম বুলি তৃতীয় পদকীয়াৰ হতুৱাই মোৰ পৰা প্ৰায় 2 লাখ টকা নিয়ে। মুঠ টকা 5,50,000 টকা বিভিন্ন ধৰণৰ চাকৰি দিয়াৰ নামত মোৰ পৰা এই টকাখিনি লৈ যায় যদিও মোক চাকৰি দিব নোৱাৰিলে। মই টকাখিনি বিচাৰি গলে মোক মিছা কথা কৈ ঘূৰাই পঠিয়াই দিয়ে। এতিয়া পদকীয়াজনে মোৰ পৰা আঁতৰি থাকে। This is the allegation, my lord.
Who is the petitioner in this case?
In this case, my lord, it is
B.A. Rohimuddin.
Rohimuddin, my lord.
But Rohimuddin is not
Another
the,
AB also there.
Rohimuddin is not an accused.
No, it is Kismat Ali, my lord.
Oh,
Accused number 2.
accused number 2.
My lord, Rohimuddin alias Kismat Ali, my lord. He was arrested, my lord.
When he was arrested?
He was arrested, my lord, 21/05/2024. Did that, my lord, 30 days, more than 30 days, my lord. In between, what happened, my lord? The matter has been settled and half of the amount has been paid to the informant with a promise to pay the remaining amount within 30 days, my lord. That fact your lordship will find the affidavit filed by the informant as per order of this honorable court, my lord, page 18.
Page 18 is the arrest memo.
No, my lord, this affidavit filed by the complainant, informant, my lord.
Okay.
I-82 definitely asking.
Okay, yes, page 18 is the
It is affidavit, my lord. It starts from page 17.
why this affidavit was filed?
Affidavit in terms of the order passed by the honorable court, my lord, at page 20.
Mr. So-and-so, learned counsel appearing for the applicant and Mr. Bisoma so-and-so, the applicant is directed to file an affidavit sworn by Ramesh Deka. He is the informant, my lord.
Okay. Case diary is there.
Case diary is, yes.
What is
The
there?
case diary is not up to date, my lord. That compromise that is not reflected here, my lord.
But they have filed on,
This is the original copy, my lord.
otherwise he is detained behind the bars.
Yes,
or-
that is there. We have no objection. They compromise some amount also paid, my lord. That is there.
Heard Mr. T. K. Bhuya, learned counsel for the petitioner.
Let us see, yeah.
Also heard Mr. B. B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Muhammad Rahimuddin alias Kismat Ali, alias Rahimuddin Ali, who has been detained behind the bars since 21/5/2024 in connection with Rauta PS case number 54/2024 under section 120/120B slash 420/406/468 of the Indian Penal Code. The gist of accusation in this case is that on 1/5/2024, one Shri Ramesh Deka had lodged an FIR before the officer in charge of Rauta Police Station, inter alia, alleging that the present petitioner took rupees
$5,50,000.
took rupees 5,50,000 from the informant on the pretext of giving him a job. However, neither any job was offered to him nor the money was returned back. Accordingly, on receipt of the said FIR, Rauta PS case number 54/24 was registered. No, now, Mr. Bhuya,
My lord.
are you agreeing that you took money for paying, for offering him job? This
I am not admitting, but my lord, as my lord, the acquisition is there, that the matter has been settled and half of the amount has been paid.
learned counsel for the petitioner has submitted that the FIR has been lodged by the informant Ramesh Deka due to some misunderstanding and the matter has been amicably settled between the parties. It is also submitted by the learned counsel for the petitioner that when this fact was informed to the court, to this court, a coordinate bench of this court by order dated 13/6/2024, directed that an affidavit sworn by the informant Ramesh Deka may be filed by the applicants. Accordingly, the petitioner has filed an additional affidavit wherein the affidavit filed by the applicant informant Ramesh Deka has been annexed. And it appears from perusal of the said affidavit that the petitioners had already paid half of the said amount to the informant, and the informant does not have any objection if the petitioner is allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Rauta PS case number 54/2024 What is the progress?
Progress, my lord, that affidavit is not here in the diary, but their statement, they say that some amount they paid, my lord. that is-
And has submitted that the investigating officer has recorded the statement of witnesses. In view of the submissions made by learned counsel for both the sides, and in view of the fact, in view of the no objection, in view of the affidavit submitted by the informant and as well as the progress of the investigation made, this court is of considered opinion that further custodial detention of the above named petitioner may not be necessary for fair completion of the investigation of Rauta PS case number 54/2024. Stop. In view of above, the above named accused is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
CJM Udalguri.
CJM Chief Judicial Magistrate Udalguri, with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of. In IA, in view of the disposal of bail application number 1556/2024, this interlocutory application is hereby closed. What is there in AB?
AB, my lord, initially AB was filed by all the petitioners, including the petitioner number in 56, my lord. On apprehension, there was no FIR, my lord. Thereafter, my lord, by an affidavit, the FIR was enclosed, my lord. The same petitioners, my lord, they are not behind the bar, my lord. The accused number 1 and accused number 3.
Who is Rahimuddin? That is BA, already arrested.
The 2 was arrested, my lord. 1 and 3 are before your lordship in AB, my lord. My lord, we will appear before the IO, my lord. We will record the statement, my lord.
Heard Mr. T.K. Bhuya, learned counsel for the petitioners. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the CRP Code of Criminal Procedure from 1973 has been filed by the petitioners namely number 1, 2, and 3, apprehending their arrests in connection with
Rota PS.
Rauta PS case number 54/2024. It is submitted by learned counsel for the petitioner that after filing of the instant anticipatory bail application, the petitioner number 2, Muhammad Rahimuddin, was arrested on 21/5/2023. It is further submitted by learned counsel for the petitioner that the said petitioner has already been granted bail by this court in bail application number 1556/2024 today itself, that is on 19/6/2024. The gist of accusation is, in this case, is the earlier gist. Earlier Agor case or gist, a case or a case. Learned counsel for the petitioners has submitted that the instant bail application is now pursued for remaining 2 petitioners, namely Muhammad Ahmad Ali and Qurban Ali. And Qurban Ali. It is submitted by learned counsel for the petitioner that the main allegation in the FIR was against Kismat Ali alias Rahimuddin who has already been granted bail by this court in bail application number 1556/2024. And the petitioners are, and as the matter has already been compromised between the informant and the main accused. Learned counsel for the petitioner has also submitted that the above named two petitioners, namely Muhammad Ahmed Ali and Qurban Ali, are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Rauta PS case number 54/2024 and has submitted that the investigating officer has already recorded the statement of relevant witnesses under section 161 CRPC. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Rauta PS case number 54/2023. As the main accused of the case, namely Ismat Ali alias Rahimuddin, has already been granted bail by this court in bail application number 1556/2024. Stop. And as investigation has fairly progressed, stop, comma. This court is of considered opinion that custodial detention of the above named two petitioners may not be necessary for fair completion of the investigation of Rauta PS case number 54/2023. In view of above, the petitioners, namely Muhammad Ahmed Ali and Qurban Ali, are hereby directed to appear before the investigating officer of Rauta PS case number 54/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If they do so, in the event of their arrest in connection with Rauta PS case number 54/24, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Send back the case diary. This anticipated bail application is accordingly disposed of. The connected, here also I is there.
Yes, madam.
The connected interlocutory application is closed in view of the disposal of the instant bail anticipated bail application.
I'm obliged.
May please the lordship. Lordship, this is a 439 application. The sections are under section 20B, 2C, 25 and 29 of the Unlimited Act. Now, your lordship will not find anything connecting me with the alleged contraband which has been seized.
What is the stage?
Your lordship,
It is
three
under,
PWs has been examined.
it is, trial is going on.
Is going on. The already I am inside the jail for 660 days. And your lordship will find.
When were you arrested?
I was arrested on 38/2022.
38/2022. How many days behind the bar?
So 660, about 660 days.
When the charge sheet was laid?
Charge sheet.
Charge sheet on 20th
20
February 23.
Yes.
When the charges were framed,
Charge frame 11/12/23.
11/12/23. After more than a year,
how many listed witnesses were there?
3
No,
out
no,
of 10.
3 already
No,
examined.
how many listed witnesses?
Listed are 10.
Out of 10,
Yes, 3 has been examined.
only 3 have been examined. How many accused persons are there?
3 accused persons. 1 has been granted bail. 1 is the absconder, and I am inside.
The co-accused was granted bail by which court?
By the special judge, Your Lordship. Where Your Lordship will find the order at page 32 of my bail application.
32, on what,
32.
on what ground?
On the ground that there were no materials against him, as because the telephonic conversations are not prima facie evidence. May I read, Your Lordship?
No. After laying of the charge sheet or during investigation?
During investigation.
Okay.
No,
No, you
no,
said
no.
that
Yes.
charge sheet has been laid against 3 accused.
Yes, after that.
No. The 14/3.
14/3,
14/3/23. Charge frame on
Charge-
11/12/23.
Charge sheet was issued
Before
on
framing
22.
charge, before framing charge.
Yes, before framing charge, yes.
So charges were not framed against this accused person?
Against Bijay Chaudhary.
Against him also charges are framed.
Against me, charges have been framed on.
Where is the charge form? Have you annexed?
No, charges I have not annexed.
Charges are framed on
Charge frame on
11/12/2023.
11/12. Yes.
Against how many accused persons?
Against only me.
Charges are framed against only you.
Yes, and another who is a absconder.
How charges are framed against absconder? In absentia. Or after framing of charge, he absconded.
No. He has on the date when the truck was apprehended, the primary accused, this driver, he fled on the same day. So from that day, he is absconding. Your Lordship will find.
Who is A1? Accused number 1?
Accused 1 is me, Jagdhari Nishan.
So charges are framed against you only?
Yes.
So that I was asking. Against how many accused charges are framed? Only you?
Only
me.
You are sure?
Yes. And Your Lordship. will see-
Now,
Yes.
what is your ground for seeking bail?
Because Your Lordship will find the only allegation against me is the confessional statement made by the owner and the driver that I was the manager of the truck where the drugs was found. So confessional statement, as Your Lordship knows, that has already been laid down by the Apex Code, that is not admissible in evidence. And another ground was that in a previous case, which was laid against the driver, this Dilip Tiwari, in that case, I went as the attorney of the owner to take Zimma of that truck where drugs were seized. So these two are the grounds.
No. I'm not clear
Your Lordship, first of all, the confessional statement by
of the co-accused.
of the co-accused, the driver.
Is that the only material against you?
Yes, that is one of the material. And another thing is that in a previous case, one Panisagar case has been referred. Panisagar PS case 61 of 21. There, another truck was caught where some certain drugs contraband were seized, and I, as attorney of the owner of the truck, went to take zimma of that vehicle. So these are the two grounds against me. And considering this, the learned court below has rejected my bail petition.
You take me to the bail application.
Your
Bail
Lordship will find the relevant portion of the order
Where?
at page 33. 14.3.22. The earlier page, Vijay Chaudhary was granted bail. The next page, 33, page 33.
Where?
As regards accused Dilip Tiwari, I'll read from there.
You are not Dilip Tiwari?
No.
No, I am not Dilip Tiwari.
You are?
I am Jagdhari
Jagdhari Nishad.
You are Jagdhari
Yes,
Nishad.
Yes. Now, according to Dilip Tiwari, I am the manager of the truck. Dilip Tiwari is the driver. May I read this, Your Lordship?
Yes.
As regards accused Dilip Tiwari, there is a extrajudicial confession over phone to have been made by him to one.
What was the accusation?
Accusation that I was managing the truck.
No. Accusation in the FIR. What was the contraband which is recovered?
Contraband is 303 packets of ganja.
Altogether,
the weight?
4,728 kg.
That Your Lordship will find at page 20.
How you were connected?
When this police interrogated the owner of the
No,
truck.
the ganja was recovered from a truck.
From a
yes.
truck, yes.
The truck was driven by
By Dilip Tiwari, the driver.
Dilip Tiwari.
Now, when the truck was stopped.
Now Dilip Tiwari is on bail or he is absconding?
No, he is absconding.
He is absconding.
Yes.
Who is Vijay Chaudhary?
Vijay Chaudhary is one helper who helped.
He was in the truck.
No, he was not in the truck.
How
but,
he got involved?
The police on interrogation through CDR, they came to find out that this Vijay Chaudhary was helping Dilip Tiwari. Your Lordship will come to page 22, the forwarding report.
No, before forwarding report.
Yes.
You tell me the accusation.
Your Lordship, may I read the FIR?
No need to read. You tell me the gist.
Gist, Your Lordship, this one.
In the truck.
The truck was, there was a Naka checking.
4,728 kgs were.
Yes, caught.
Where only Dilip Tiwari was.
Yes, Dilip Tiwari absconded before that.
Who was arrested?
No one was arrested. Later, Vijay Chaudhary was arrested on interrogation.
No, how Vijay Chaudhary came to picture?
That Your Lordship can get from the forwarding report.
Okay, take me there. Where is the forwarding report?
At page 22.
Yes.
May I read, Your Lordship?
Read relevant portion only.
Yes, with reference to the above, I would like to inform you that during routine Naka checking at Churaibari on 29 August 2022, one truck bearing so-and-so was intercepted. During checking, 4,700 kg ganja were found concealed under natural rubber in the truck. However, the driver managed to escape, taking advantage of darkness and traffic congestion. During investigation, it was found that C truck had a fake number plate, and as per engine number, the actual registration number of the truck is A01GC7349. By going through the transport record, it was found that both the registration number 1894 and 7349 were registered in the name of Satiram Kiwat of Fancy Bazar. This is the owner of both the trucks.
Okay.
Accordingly, he was interrogated and found though the trucks were in his name, but it was operated by his brother. I have come into the picture now.
You are the brother
Yes.
of,
Brother of the owner, according to the owner, was managing the truck. Subsequently, Jagdhari Nishat was picked up and forwarded to judicial custody. He had mentioned that the seized truck was driven by one Dilip Tiwari of UP. From further inquiry, it was learned that Dilip Tiwari was driving the truck and his phone number were so and so, so and so. It was noteworthy that during investigation, it was found that Dilip Tiwari was arrested in Panisagar, the previous case which I was referring to, Panisagar PS case.
what previous case? I have not understood.
Your Lordship, in regard to this truck, this particular truck, 1894, which has been referred to in this paragraph.
Yes,
There are two trucks, 1894 and 7349.
but the contraband was seized from
Yes,
7349.
the contraband was seized from 7349.
Yes,
Now, in regard to this Panisagar PS case, there the truck number 1894 was apprehended.
now how this Panisagar PS case comes into picture?
That the prosecution has brought to show that I, as attorney, I went to collect Zimma of that vehicle.
No, you go in a sequence. The contraband was seized from
7349.
7349,
Yes,
where nobody was found as
Where
the
nobody-
driver has absconded.
yes,
And during investigation, owner was located.
yes.
Owner said that my brother was
Brother
handling
was
this
managed.
truck.
Yes, yes,
You are the brother.
yes,
You came to picture and you were arrested.
yes.
Then
Then your lordship, on CDR analysis, the next paragraph. On analysis of CDR of Dilip Tiwari, it was established that he was present in Churaibari on so and so evening and had escaped to Bihar, Dharmanagar. Further analysis revealed that the ganja was suspectedly located at Sidhai. During loading period, one phone number, so and so, was found to be constantly in touch with the accused driver, Dilip Tiwari. Now, this phone number pertains to Vijay Chaudhary. Was constantly in touch with accused Dilip Tiwari, phone number so and so, for more than 2 hours. Further, there were many common numbers in this number CDR. The so and so number was taken, found to be registered in the name of Vijay Chaudhary, son of so and so. Accordingly, one team was sent to apprehend him from Tripura. So this is how Vijay Chaudhary comes into picture. Now, in regard to my forwarding report, your lordship will find in the next page, page 23.
yes,
May I read the brief facts? The brief facts of the case that on 29/8/2022, SI Niranjan Das of Churaibari during regular Naka intercepted one truck parked near Naka Point.
no, skip that because this is common.
Yes, yes. Then the grounds of arrest. The arrested person is the co-owner cum driver of the seized truck. During investigation, it has been found that seized vehicle 1894 was registered in the name of Satiram Kewar, Fancy Bazaar. It was financed by so and so and found that the truck was under a transport.
This is also same.
Yes. Now, your lordship may come to the 12th line. Engine number physically present was checked in records.
No, you read 3-4 line above that.
Accordingly, the same
Accordingly,
truck,
from
yes,
accordingly,
yes, was seized bearing registration number 1894 along with documents. Since there were two trucks bearing the same registration number at two places, it is strongly suspected that one of the seized truck was stolen one. Therefore, a closer inspection has been made of the seized truck 1894 at Churaibari was done and found that engine number presently physically is so and so and chassis number physically was illegible as it was grinded, but the N numbers were 164. The engine number physically present was checked in record and found to be belonging to two trucks, namely 4656 belonging to Bikaner Assam road line and 7394 belonging to Satiram Kewat of Ganesh Market, Fancy Bazaar. Further, the chassis number corresponding to the above engine number was found to be ending with 164, which strongly established that the truck seized at Churaibari was actually 7349 and not 1894. That means this 1894 number plate was being used on the truck which was actually caught, which is 7349. But both the trucks belong to Satiram Kewat. Therefore, inquiry was made at RVL Finance, Guwahati. and found-
Ultimately, it was found that the truck was operated by you.
Yes, yes. That is the
And there-
confessional statement.
And therefore,
Therefore, I was arrested.
now what is your defense?
That confessional statement, that is not
No.
admissible.
Apart from confessional statement,
Yes. And the second,
if there is other material to show that the truck belongs to you, you were operating the truck where the ganja was seized.
but actually the truck which was seized from me, that was 1894. That your lordship will find in the seizure report, which is at page 25. The truck in which the actual ganja was caught, that is 7349.
Yes.
And the truck which was seized from me, which your lordship will find at page 25, seizure report. Item number 2 of the seizure list, that your lordship will find as 1894.
Okay.
So this number, this truck was under my possession. And
1849 was in your possession.
in my possession, that was seized by the police. But the actual ganja was caught in 7349, and as per the owner, I was also managing that. So that is the confessional statement linking me with the alleged contraband which has been seized. So my what I want to say is that
What is the other material apart from this statement of?
the other material is that Panisagar case which I was referring to.
No, this truck does not belong to you.
Yes, I was not managing this 7349. The only truck which I was using is 1894.
Okay, what else is your submission?
Is that in that earlier case which the court below has referred to, I was only the attorney of the lawful owner. So there was no case registered against me. It was against the driver of the truck. So how that case can be clubbed along with this present case here? So these are the two grounds implicating me in the present case.
Yes, Mr. Gogoi. Anything else?
Anything else, my lord, that is in the forwarding, it is says that further the chassis number corresponding to the above engine number was found to be ending with 164, which strongly established that the truck seized at Suraibari was actually AS 01G7349. Actually, it is 7349 and not 1894, but both the trucks belongs to Sitaram Kewat. Therefore, equally was made RVL Finance Guwahati and found that the truck number.
When the charge was framed?
My lord.
Charge was framed on.
Charge
11,
frame on 11/12/23.
And another thing which I want to point out to your lordship, I am saying that my the truck which was seized from me is 1894. So obviously I will not use that number in another truck.
No,
And
but
load-
these questions will be decided in trial.
That is. But
Can this help you in a bail where commercial quantity has been seized and
otherwise only material against me is the confessional statement of the owner.
but you have not challenged the framing of order against framing of charge?
Your
Mm,
lordship,
the
I have
Order
not-
of framing of
Decision
charge
bail
against you.
application, no?
Yes, I have not got these charges.
Yes,
So, my lord, actually this contraband recovered from his truck, my lord, that is 7349. And number plate may be changed, my lord, it is not so difficult. And he was the driver, my lord, the present person, petitioner, my lord.
in years and month, how much it comes? 666 days.
660 days from the date of arrest.
It is 1 year and how?
1 year, 9 months and 20 days. Around 1 year, 10 months.
Any other submission?
Sure.
Heard Miss S. Heard Mr. S. Datta, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Let this case be listed for delivery of orders. On Monday, I will deliver.
Your lordship, another thing I want to point out. Your lordship may come to the FIR once at page 19. The last paragraph, your lordship. I have sought authorization letter to search and seize the suspected ganjas to CI Ramakrishna Nagar Police Circle, and I received the same at about 9:20 PM to WhatsApp message. So whether this WhatsApp message is valid without there being certificate in terms of section 65B of the Evidence Act.
Okay. On Monday. What is the date? 24/6.
Obliged.
Can you pass over the matter for time?
Wait, please, your lordship. The 439 application, your lordship. This NDPS matter here. Here, your lordship, the petitioner was arrested on 36/2021. Two of the petitioners were arrested on 36/21. One was arrested on 28/7/20. Charge sheet was laid
How
out.
many petitioners
There
are
are three here in this matter. There are three petitions.
Three petitioners.
Three
Who was arrested on 36?
Petitioner 1 and 2 on 36, and petitioner number 3 was arrested on 28/7/2021.
2020.
21. Both are in 2021, about a month different between the. And your lordship, this charge sheet was laid on 24/12/2021. And till now, not a single witnesses have been examined. And
When charges were framed?
charges were framed, your lordship, on just a minute. It was framed on 28. Sorry, it was framed on 21 to 2024.
21 to 20.
2024. After nearly 2.5 years.
Why so delay? You are ready?
No, Lordship, I am adjourning the matter, Lordship. My senior is in Lexington Court number 1, Lordship. It may be fixed on Monday or Tuesday, Lordship.
Now let it be on Friday. Why Monday and Tuesday?
Okay.
Long-
Charge was framed on 21 to 20
24 years.
recently.
Wherein the charge sheet was filed in 21.
How many listed witnesses are there?
There are 10.
Why there was,
11 weeks, sorry.
why there was delay in framing of charges?
That, your lordship, the scanned copy has been called along with the status report.
Okay, you also go through.
But I have not.
I could not check, lordship.
Let,
That's all.
let us fix it on Monday. Let them come prepared. Heard Mr. Y.S. Manan, learned counsel for the petitioner. And what, how much it comes to years and months?
It comes to about, your lordship, nearly, the first petitioner number 1 and 2 comes to nearly 3 years. And petitioner number 3 also about a month less than 3 years. So today's 19th, it is 30th, 36. So nearly 3 years.
Heard Mr. Y.S. Manan, learned counsel for the petitioners. Also heard Ms. M. Deka, learned counsel for the NCB, who prays for an adjournment on the ground that Mr. S.C. Kayal, learned standing counsel, NCB, is on legs in a different court. And
Court number 1.
requested to release this matter on
35.
24/6. Learned counsel for the petitioner agreed to the same. Let this matter be listed on 24/6
Monday.
for bail hearing on Monday.
This also,
Same prayer, lordship.
in fact, the same, no, it's a different matter. But the
Same
same
order,
prayer as
same order.
here it is 6 years.
6 years.
That is why I'm saying, so at least matter could be taken up earlier. Let this be on Friday. If possible. Otherwise, I have no problem on Monday also.
No, let it be on. Same order.
There's another matter, your lordship, item 25. This may also be on Monday,
Let it be on Tuesday,
25.
25. 25 is on Tuesday.
Lordship.
Highly obliged.
Must be.
May I be the lordship, in the morning, my senior sought time in this matter, Because the FSL report has not been received.
Yes.
Lordship, kindly see the observed 25, 20th of May,
Or see,
was called for,
what was seized?
Ganja, from one petition number 1, around 21 kilos. And from the other petition, more than 100 kilos.
Heard Mr. N. Mahajan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. It appears from record that by order dated 25/2023,
24.
2024, the FSL report in connection with this case was called for. However, same has not arrived. Who will produce addition? Yes. Mr. Gogoi will produce it. Learned additional public prosecutor prays for some more time for producing the FSL report. The prayer is allowed. Let this matter be listed again on, when do you want? When?
After vacation, my lord. 16.
16/8, 16/7, 16/7 for FSL report.
May I pray that the case there may be retained, otherwise they send it back.
Yes, there is there.
Only FSL is required. The diary is up to.
Why FSL is necessary?
On last occasion, my senior made some submissions, then
Oh.
FSL was called for one.
Okay, FS,
Regarding the weight and everything, some submissions were made.
okay.
Same.
The case diary may be retained till next day.
Obliged, highly obliged.
No, case diary, it is a long time. Instead of retaining, they will again come.
Yes, sir.
Sir, can it be before vacation then?
Then before vacation, no, sir. 28, 28/6.
28. Instead of July, change the date. 28/6. The
20.
case diary be retained till next day.
Obliged.
Item. Yes.
Again, commercial quantity, my lord, I was arrested on 13/3/24, my lord. As on now, my lord, 98 days, my lord. Purely on medical ground, my lord.
It is undergoing during investigation stage.
During investigation. My lord, my respectful prayer will be, my lord, on the last occasion, I have submitted a photograph, my lord. Probably it will be part of the record, my lord. If not, my lord, I'm seeking permission to hand over the photograph, my lord, to show that what is my medical condition, my lord. I'm a cancer patient, my lord.
No, where are the documents?
Documents with my file and specifically medical document was called for, my lord. In my petition, page number, starting from page number 220, my lord. These are the medical terms. Page 20, my lord. Paragraph 3, treatment, my lord. FNSC, SCC. I have taken assistance from my brother of this medical term to understand. This is squamous cell carcinoma carcinomas. This is clearly indicate, my lord, this is the last stage, my lord, as far as cancer patients are concerned, my lord. And a photograph purely on medical ground, my lord. And I like to quote one of the greatest legal minds, my lord, Fali Nariman once said, my lord, I'm at the departure launch of Godse Airport, my lord. Probably the picture will show, my lord, from the medical report, my lord. Here it is. This is the condition, my lord. Not on merit, purely on medical ground, my lord. As of now, my lord, it is under investigation, my lord, 98 days, my lord.
No, you have to show something.
Yes, my lord. And
something to convince this court that FNAC-SCC means last stage of cancer. Which authority you are relying?
medical report, my lord, from the hospital jail authority has come, my lord. My lord will find from the medical report, my lord. Medical report.
ডায়েরি আছে না ডায়েরি মেডিকেলের কথা নাই চার্জশিট হয়েছিল এমনি টেস্ট করতে
চার্জশিট হয়েছে
এক মিনিট TPS as a case is charge-sheeted and the case diary is required to submit final form before the honorable court. Yes. Now.
Is there?
Yes, case diary here, it is just. Now, they have complete the investigation, my lord, the charge sheet ready.
What is the name of the UTP? Shahid Hussain.
Shahid Hussain, Elas Shahad Hussain, my lord. Spelling page.
Serbian. তাতেই ভর এটা না হয়ে যান all these are my nearest. These appearances look like Manipuri boy. Size at say that.
Size.
How?
No, but you are getting treatment.
I'm getting treatment, my lord, but as far as my information is, my lord, for cancer treatment, our jail authority do not have.
No, he is being treated at cancer hospital. You have to show some authority that a person accused suffering from cancer can be granted bail on that ground only.
Supreme Court decision.
In that case, my lord,
to overcome the embargo of section 37.
then day after tomorrow, my lord.
Any day you want.
Tomorrow.
You are not seeking interim bail.
I have not prayed, my lord, in the prayer petitions, my lord. Initially, when I have prepared this, not amended my prayers, my lord.
Now, what is your prayer?
At this prayer, my lord, regular bail. And then, my lord, on medical paper, we have sought from the medical authority, my lord. We will be getting it by tomorrow, my lord. With that petition, my lord, we will file an additional applications within amending prayers that, my lord, for interim protection.
Then file that
Limited,
application.
1 week time, time লাগিব.
You
আৰু Supreme
file
Court
that
decision
application.
লাগিব.
You come prepared also instead of day after tomorrow. Let us fix it on Monday or Tuesday.
Next Friday or Monday, my lord.
Whenever you want.
As per your convenience, we have
Friday.
no problem.
This Friday.
This Friday.
Or you will file an additional interlocutory application
Most likely, my lord.
that I can reflect in the orders.
Yes, my lord.
Heard Mr. R.A. Tapadar.
Yes, Tapada.
A.S. Tapadar, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner intend to file an interlocutory application in this case. Moreover, he also submits that he needs some time to place some authorities in support of his submission, in support of the submissions made by him, and hence prays for some made by him. Stop. The prayer is allowed. Let this matter be listed again.
When?
Any date as per the conviction.
Your convenience, court today, সদায় ready.
Let it be on Tuesday,
25 today.
25/6/2024.
I'm deeply appreciative.
Item 26.
May I please the lordship?
Yes.
My lord, this is my lord under NDPS Act, my lord. The petitioner, my lord, is Idris Ali, my lord, the accused number 3, who is a, my lord, admittedly, my lord, my lord, Rapido rider, my lord. He, my lord, was booked by the accused number 1 and 2 for picking up them, my lord, from the place of occurrence. My lord, he went there, and thereafter, my lord, police accosted the accused number 1, 2. Then I was also there, my lord, for picking up. As per the call, my lord, they have booked for the Rapido riding, my lord. I arrived there, my lord, and the police accosted, my lord, the accused persons. My lord, seized, my lord, recovered, my lord, 20, my lord, some sort of, my lord, your lordship will find Yuba tablet, methamphetamine, my lord. From the possession of the main peddler, my lord, accused number 1, Habibur Rahman. My lord, I am no way, my lord, involved in the alleged incident, my lord. I am a Rapido driver, my lord. I went there for the purpose of the carrying passenger, my lord, and purely on suspicious ground, my lord. The police on 17/10/2023, my lord, arrested me as well as the other accused persons, my lord. And since then, my lord, I am languishing in jail, my lord. It is about 8 months, my lord. I am behind the bar.
Charge sheet has been laid.
My lord, it is filed, my lord, on 5/4/2024. Now the trial has begun, my lord. It is fixed for copy. Now, my lord, your lordship kindly consider, my lord. Your lordship knows, my lord. My lord, there are scatenas of judgment by the Supreme Court, where my lord, the Supreme Court has said, my lord, the bail is the rule, my lord, and jail is the exception, my lord. Your lordship knows, my lord. My lord, here is a case your lordship will find, my lord, that there is no possibility of, my lord, expeditious trial, because your lordship will find, my lord, at page 37, my lord, I have annexed the order of the Honorable Trial Court, my lord. Page 37 goes to show, my lord, it is fixed for copy. Now, my lord, there is a reason to believe that there will be an inordinate delay in disposal of trial matter. So, if that being so, my lord, in Vernon's case, your lordship knows, my lord, Vernon versus State of Maharashtra. My lord, civil appeal number, your lordship, my lord, I have noted, my lord. Civil appeal number, my lord, 683 of 2023, date of judgment 28/7/2023. My lord, in that case, the Supreme Court, my lord, four accused persons were arrested. That was in
So you are
UAPA case.
referring to civil appeal.
No, my lord, criminal appeal.
Okay.
Criminal appeal. My lord, in that case, Vernon Gunjalves, Sudha Varadwaj, my
You
lord,
have brought
Soma
that,
Sen.
brought the judgment.
I have not, my lord, but I have the citation, my lord. I will give it, my lord. That, my lord, in the ratio of the judgment will apply here in this case.
What is the ratio?
Ratio is, my lord, that if there is inordinate delay in disposal of trial, my
Now
lord,
you want to say that there is inordinate delay in this.
my lord,
But you are behind the bars for last 8 months.
8 months.
You show a authority which shows that for 8 months delay, only on that ground you may be granted bail.
I am not on that. What I am on is, my lord, if there is, my lord, delay, inordinate delay in disposal of expeditious trial, my lord, that gives a right to the accused person under Article 21 of the Constitution of India, my lord, for, my lord, grant of bail. Because,
Yes, that I agree.
yes, my lord, 21, your
But
lordship
that
is not
delay,
only-
whether 8 months falls within that category, that help I want.
Yes, my lord, of course, my lord. If
Show
there
me
is-
show me a.
My lord, I'll show it, your lordship, my lord, because that judgment that I have cited, my lord, that is the judgment, my lord. I'll give it, my lord. Your lordship may have it on day after tomorrow, my lord.
Okay, you
I'll
come
satisfy.
prepared. Let him,
I'll satisfy your lordship. The
Okay.
judgment where it says, my lord, if
not
there
day
is-
after tomorrow, Tuesday. You come fully prepared.
Otherwise, my lord, it file on 2nd February
Yes,
2024.
because otherwise I am not convinced that 8 months would qualify you to get bail on long incarceration. But if you can satisfy, that is okay.
My lord, your lordship kindly consider, my lord. Your lordship is not only, my lord, dealing with an application.
No, you
under
come prepared, fully prepared with all the judgments and whatever authorities you want to relate. Heard Mr. B.K. Sen, learned counsel for the petitioner, also heard Mr. R.R. Kaushik, learned additional public prosecutor. Learned counsel for the petitioner submits that yes, prays for some time to go through some more authorities which he intends to rely and place the same before this court on the next date fixed in support of his submissions. The prayer is allowed. Let this matter be listed on Tuesday. 25/6. 25/6.
25/6. I am obliged to that. I am obliged. My lord, I am only on that count, my lord, that if there is, my lord, inordinate delay in disposal of trial, my lord, then it gives a right to the price. I am obliged to that.
27 CD not received, my lord.
My please. Madam, this matter may be taken, madam, next week, my lord. CD is not available, madam.
And service whether complete or not.
Heard Mr. S. Rahman, learned counsel for the petitioner, also heard Mr.
I am appearing, I have filed the wakalat number today, man.
For the informant.
Respondent number.
Okay.
Yes, informant.
Also heard Mr. R. Kaushik, learned additional public prosecutor, as well as Mr. N. J. Datta, learned counsel appearing for respondent number 2. Learned counsel, learned additional public prosecutors prays for some more time for producing the case diary. The
27.
prayer is allowed.
Okay.
Let this matter be listed on 27th June 2024.
Bless.
Wait, is all offset.
My lord,
This
28 also.
matter involves, my lord, intermediate quantity.
Intermediate.
Yes, he is behind bars since, my lord, 24/3. That will be, my lord, around 57 days. And probably, my lord, charge sheet has also not been submitted. So on the
My lord,
ground
can
of-
it be fixed on tomorrow? I will take instruction whether charge sheet submitted or not.
Is there?
Yes, there is not here. my lord.
Let it be on tomorrow. Let him find out. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. Learned counsel for the petitioner has submitted that this case involves contraband of intermediate quantity for which the maximum statutory period of detention is 60 days. And the petitioner has already undergone detention for 57 days. Stop. However, learned additional public prosecutor sought for some time to find out as to whether charge sheet has been laid in this case or not. The time sought by the learned additional public prosecutor is allowed. Let this matter be listed tomorrow, that is on 26, 2024.
Highly obliged.
Yeah, please, Lordship. Lordship, the LCR, my lord, I have inquired in the registry office. My lord, the LCR has been received, but my lord, in apparently the.
LCR is not there.
Tag on the record.
It has not been received, that is the office note. We are fixing a short date. Heard Mr. What is your name?
Ziboro.
Heard Mr. C. Boro, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. From the office note dated 10/6/2024, it appears that the scanned copy of the trial court record which was
My lord,
called
this
for.
is NCB case, my lord. We are not representing.
Okay. None has appeared for NCB. This is item number. Okay. That NCR has not been received. The trial court record has not yet been received by the registry. Registry to issue reminder for the trial court record. Let this case be listed again on give before 26/6/2024.
May I please, your worship? Lordship, in this case, lordships, the petitioner has been arrested against an NBW order, lordships. You'll find lordship page number 19, lordships, annexure.
Page number
19, lordships.
yes,
May I read, lordship?
yes.
Lordships, accused person Miran Sikdar is present. Remaining accused persons Saiful Islam Siddiq, the petitioner, lordships, and Shahidul Ali are absent. Summon issued to the accused. Saiful Islam Siddiq has not returned with any report. It is the case about divergence that summons to the accused person was issued on multiple occasions. However, the attendance of the accused could not be complied with. Neither any report has been received regarding the service of the summons from the executive authority, lordship. Considering the nature and tendency of the case, I am of the opinion that no purpose will be served by issuing summons afresh to the accused of the hands. I deem it fit and proper to issue NBW against the accused Saiful Islam Siddiq, lordship. This is the.
Okay. Thereafter, what happened?
Thereafter, on 14/5/2024, lordship, he was arrested by the police of Nunmati PS and produced before the landed court below.
When you were arrested?
On 14/5, page number 20, lordship, 14/5/2024.
Then you prayed for bail before the,
On the same day, lordship.
where is the rejection order?
That was page 20, lordship. Later on, lordship, at 2 pages.
What is the offense?
376, 346, 346, 34, I will see.
376.
Yes.
Now, what ground you are praying for bail?
Lordship,
The trial-
someone was not served upon the petition of lordship. And he was completely unknown about the proceedings of this case, lordship.
During investigation, whether you were granted bail?
Yes, lordship. Page number, lordship. Page number 16, lordship. Has granted in anticipated bail, lordship. Page number 16, lordship.
By which court? High Court.
Yes.
Judicial Ministry.
Yes, Ms. Das.
Summon to the accused was issued on multiple occasions as per order 9/11/23.
But someone was not served.
Yes, lordship.
And here in 14/5, order dated 14/5/24, lordship, the accused Saiful Siddiq produced before.
Why someone was not served on you?
The petitioner is a permanent resident of Nunmati, lordship. Guwahati.
And where the summons were issued?
Yes, as well, lordship.
Now, what is your submission?
The petition was not served with the summon. He is completely unknown about the proceedings of the case, lordship.
No, okay. But you knew that a case is pending against you. You were on anticipatory bail.
Yes.
Here it is mentioned that lordship, the said accused is not found in the address, and from the local public, it has been informed that the accused is presently residing at Kerala.
This is another lordship. This one is another, Shahidul Ali. I am not Shahidul Ali, I am Saiful Islam Siddiq. Lordship, recently, lordships, on 14th of June, lordship, then that particular accused person has already arrested and also released on bail, lordship, by the session just, assistant session just going on.
Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Saiful Islam, alias Saiful Islam Siddiq, who has been detained behind the bars since 14/5/2024 in connection with PRC case number 670/2022 arising out of Manikpur PS case number 151/2014 under section 366/343/376/34 of the Indian Penal Code. Learned counsel for the petitioner has submitted that the petitioner was arrested on the strength of non-bailable warrant of arrest issued by Learned Chief Judicial Magistrate Bongaigaon in PRC case number 670/2022. Stop. However, it is submitted that when prior to issuance of non-bailable warrant of arrest against the present petitioner, Learned Committal Court had issued summons to the present petitioner. However, without ascertaining the due service of summons on the petitioner, the said court issued non-bailable warrant of arrest against him. Learned counsel for the petitioner has submitted that the petitioner was not aware about the pendency of PRC case number 670/2022, as he received no summons from the court in respect of the said case, and he was directly arrested on 14/5/2024 on the strength of non-bailable warrant issued against him. It is also submitted by learned counsel for the petitioner that during the investigation stage of the case in the year 2020, the petitioner apprehending his arrest had approached this court, and a coordinate bench of this court by order dated 6/1/2020 passed in AB case number 4244/2019 had granted anticipatory bail to the petitioner with certain conditions. The petitioner, learned counsel for the petitioner, submits that the petitioner is ready to cooperate in his trial. You are permanent resident of?
Nunmati.
Stop. Ms. Das, you have any submission?
No, sure.
I have heard learned additional public prosecutor also, as well as peruse the scanned copy of the PRC case number 670/2022. Bare perusal of the order dated 9/11/2023 would reveal that learned Chief Judicial Magistrate Bongaigaon on the said date had issued non-bailable warrant of arrest against the present petitioner without ascertaining due service of notice, due service of summons issued by it on him. Stop. Under the said circumstances, it may be presumed that the petitioner was not aware about the pendency of the PRC case number 670/2022. Moreover, the petitioner was also granted anticipatory bail during investigation by a coordinate bench of this court as already submitted by learned counsel for the petitioner. The petitioner has already completed more than, at what stage it is pending? Copy has been furnished.
Your lordship, all 28 seizures were fixed for CC lawsuits. A case has already been committed. to the-
Committed.
Oh, yes, lordships. By session case number 33/20.
You have not prayed for bail before sessions court.
Your lordship, on last 14th of June, lordships, is committed, lordships.
You should have prayed before sessions court.
Yes. Lordship.
Thirty days. This bail application is disposed of with a direction that the petitioner may approach the trial court. No, before that. Learned counsel for the petitioner has also submitted that in the meanwhile, the PRC case number, you have not made full submissions while making your submissions. PRC case number 670/22 has already been committed to the sessions court, and what is the sessions case number?
33/2024.
You should have submitted about this while making your submissions. This has cost you your bail. You have to wait. What? Sessions court and sessions case number 33/2024 has been registered and same is pending before the court of learned
Assistant Session Judge.
Assistant Session Judge Bongaigaon. In view of observations made herein above, this bail application is disposed of with a direction to the petitioner to appear with an observation that the petitioner may file an application seeking bail before the learned trial court, and if such an application is filed, the same shall be considered by the said court, after considering the facts which are highlighted herein above in this order. This bail application is accordingly disposed of.
May it please your lordship. This is a 439 bail application, lordship. In this case, two petitioner before your lordship.
Item number 40?
31.
31.
May it please, lordship.
Yes.
439 lordship, two petitioner before this court, lordship. That is one petitioner number is Jahil Hassan and second is the lordship Arshad Ali, lordship.
Now they are in jail custody for 109 days, Lordship. The FIR Lordship will find on page 17, Lordship.
109 days. It is still under investigation.
Still under investigation, Lordship.
Page
Page 17, Lordship. Type copy in page 17 and that Xerox that is on page 19, Lordship.
what?
May I read, Lordship?
What is the accusation? What is the contraband which is?
As per Lordship, this FIR Lordship contraband recovered Lordship. May I read the entire FIR Lordship?
No, it will take so much of time. It is a
262
long
gra-
affair.
262 gram of Lordship heroin recovered from the shoulder bag of accused number 1. Not from the accused number 2, that is a petitioner number 2, Lordship. 262 gram, Lordship, that is on page. On the bottom part, Lordship, fifth line from the bottom, Lordship, on page 17. They were checked in presence of the local witness and recovered 20 shock box containing as many as that is 20 packet of suspected heroin. Were found inside the shoulder bag of Jahil Hussain. The same was weighed and found 262 grams without cover, which was seized in presence of the witness by the preparing a seizure list by adopting all the formalities laid down. Then, Lordship, forwarding
You are Arshad Ali.
2%, Lordship. I'm for the 2%, Lordship, from Jahil Hassan and as well as the Arshad Ali, Lordship.
You are for both the petition.
Yes, Lordship.
And
Regarding
the contraband was recovered from the
petitioner number 1, Lordship.
Jiaul Hassan.
Lordship. Jiaul Hassan.
Now
Now,
what is your
Lordship,
submission?
Now, Lordship, section 50, that his right to search in presence of the Lordship magistrate that was not informed applies to this petitioner number 2, Lordship, as well as petitioner number 1, Lordship. Since the recovery was from the shoulder bag, Lordship, from the petitioner number 1, Lordship, regarding petitioner number 2, there is nothing recovered from petitioner number 2, Lordship. So in this case, Lordship, the 51 that is guideline provided in section 50 of the NDPS Act, Lordship, has to be followed, Lordship. He has to be informed regarding his search, Lordship. In that
Even if the contraband was found in a bag.
That's why, Lordship, I'm submitting for the petition number 2 first, Lordship.
Okay.
So he was not informed his right, Lordship, which vitiated.
What was found from petitioner number 2?
Nothing was found from the petition number 2. As per FIR, so far in the forwarding report, Lordship. That is on page 20, Lordship.
How he was connected with the offense?
Now, Lordship, there is no specific, only, Lordship, forwarding report, Lordship, ground that is on page 21, Lordship.
Okay, you were traveling in some.
They caught with this petitioner, along with the petitioner number 1, Lordship. This petition number 2 was caught, Lordship, with petitioner number 1, Lordship. Now, ground of Lordship, the ground of arrest, Lordship, as stated in the page 21, Lordship. The accused person or FIR name accused person. Sufficient incriminating evidence has been found against the arrested accused person. The arrested accused person are habitual offender and notorious drugs peddler, and had Amingo been arrested also that case. Lordship, they have stated they are a habitual offender, Lordship. No previous track record was given, no previous case number was given in the forwarding report, Lordship. How many cases are pending against them, Lordship? It was not stated in the forwarding report, Lordship. And moreover, Lordship, one of the accused petitioner, Lordship, who was also arrested in this case, Lordship, he was granted bail. That order, Lordship, will find on page 29, Lordship.
But he was the third accused with.
Yes, Lordship, third accused.
From whom nothing was seized.
That lordship accused, that is on page 29, lordship. Some drugs were recovered, that is 10 bottles of Fansidel, lordship, codeine syrup recovered from him, lordship.
Okay. His case is different case,
Yes, this out of this same case,
but
lordship.
his
But-
missions are different.
Yes, lordship. Now, lordship, as per that, lordship, he was the supplier of these drugs, lordship. Whether the lordship that was reflected in the case diary or not, lordship. Now, the thing is that, lordship, since 50 has not been complied with, lordship, this petition gives such privilege to release on bail, lordship, because they are not informed about their rights, lordship. They were not such in presence of the magistrate, lordship.
Fifty as regards petitioner number 2.
Regarding petitioner number 1, lordship, let him remain some more days, lordship. Regarding petitioner number 2, he is not connected with the alleged offense, lordship. Unnecessarily dragged into the case, lordship.
Yes. Yes, Mr. Go.
Yes, that petitioner number 2, my lord, he was with petitioner number 1, my lord, moving, my lord, in the same vehicle, my
No,
lord.
what materials are there?
The material, my lord, contraband not recovered from his possession, my lord, exclusive possession number from number 1.
Section 50, any judgment?
Regarding 50, lordship, I rely on this, lordship, too.
Here, my lord, FSL yet to receive, my lord.
Yeah, we assume that it is heroin.
Now it is suspected. Now it is suspected.
Then what is the case of the prosecution?
Now yet to be cited, not submitted, my lord. Investigation is going on.
No, what is your response to the submissions made by counsel?
Now it is recovered from his possession number 1.
Number 1, he is not pressing, it
Yes.
appears.
Then
Number 1, he
other one was along with him, my lord. Yes. Nothing was recovered from his possession, my lord.
case diary.
Yes.
I'll go through the case diary.
Yes.
What is this 50?
That, lordship, regarding, lordship, where the section 50 is mandatory.
No,
or
no, you don't give a bunch of.
This
you-
two, lordship, I flag mark that, lordship, one for, lordship, paragraph number 5, lordship, just given the and the bunch of the case, not that one, not, lordship, first one is there. And regarding 50, that has been discussed in para 20, para 24 of that judgment, lordship, 2010. Can you peruse that, lordship, refer in the 2010 volume 9 SCC 608 para 5, lordship. 2-page judgment, lordship.
No, Mr. Gogoi, is
Not
there
it.
anything else connecting accused number 2?
No, that is, he was with him, my lord, or moving with him, my lord. But 161 says that they are jointly doing this business since last 3-4
They have
years.
to substantiate by, lordship.
That is
stating,
161 statement.
161, whose statement?
Both, my lord. I have flag mark, my lord.
Okay, I'll go through it. I'll keep the case diary. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Let this case be listed for. Arveta fix कितने आसे? 24 की है, right? Friday.
Highly obliged.
20. This Friday. Let this case be fixed for delivery of orders on 21/6/2024.
Highly
I'm
obliged.
keeping case diary with me.
May I please, Lordship? Yep. CD was called for, my lord, and POSCO matter, my lord.
CD received, my lord, POCSO. So far, notice, my lord, sir.
What was stolen?
My lord, that FI is there, my lord.
Where is the FIR?
Yes. My lord, FI is at page. FI is page 13, my lord.
What was stolen?
My lord,
Earring.
Jewelry, my lord.
jewelry, my
Yes.
What is what CD says?
My lord.
Case diary?
Case diary, my lord, they were involved in this offense. Earlier also, they have done this kind of thing, my lord.
But in this case?
In this case, he is involved, my lord. And my lord, he used to steal this kind of jewelry. After molding them, they used to sell to other jewelers, my lord.
Now, what is your submission? What is your submission first? Hajorika.
My submission. My lord, he was arrested, my lord, not from the spot, my lord. It was only under suspicion because he was arrested in some other case, my lord. So perhaps under suspicion, my lord, he has also been named in this case, my lord.
Because
And-
earlier he
Yes,
was,
earlier, my lord, that another case, it is 86 of this Hattigaon police station, my lord. And earlier he was arrested in 87. So perhaps in the same police station under suspicion, my lord. He was also shown arrested in this case. My lord, I only pray on the length of detention, my lord. Otherwise, I will cooperate, my lord. I have been cooperating, my lord.
Otherwise, my lord, in this case, police got other accused person, my lord, on their statement, his name crop up, my lord. And he was already arrested in different case. Subsequently, he was shown arrest, my lord. So far, this case is concerned, my lord, since my
you
lord.
were arrested when?
Here, originally I was arrested on 2/5, my lord. But in this case, I have been shown arrested on 21/5, 27 days, my lord.
When this FIR was lodged?
This FIR was lodged, my lord, huh?
1/5.
1/5, my lord. Nothing has been recovered from his possession. my lord.
Apart from the statement of co-accused, anything else?
Well, other jewelers to whom these people used to sell jewelry, stolen jewelry. They didn't knew that those are stolen. They bought them after molding them. Their statements are also here, man.
So molding, how will you identify that it was the same?
Well, investigation is going on otherwise in the respect level.
My lord, on any condition, my lord, I am duty bound, my lord. I have to face trial.
No, you will face trial only if during investigation something is found against you. No?
My lord, and I humbly submit, my lord, at this stage 27 days, and that too, my lord, shown arrest. Nothing had been recovered, my lord.
Okay.
Neither they have been, my lord, nabbed at the place of occurrence.
Heard Mr. P.H. Hajorika, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Siraz Ali alias Chiraj Ali, who has been detained behind the bars since 2/5/2024 and who has been shown as arrested in Hattigaon PS case number 86/2024 on 23/5/2024. It is pertinent to note herein that before his showing arrest in the Hattigaon PS case number 86/2024, the present petitioner was arrested in connection with Hattigaon PS case number
87 of 2020.
87/2024. The accusation the gist of acquisition in this case is that on 1/5/2024, one Rohit Kumar Thakur had lodged an FIR before the officer in charge of Hathigaon Police Station, inter alia, alleging that a theft took place in his residence at the first floor of Muktinath Housing Society, house number 87, Ajanta Path, under Hathigaon Police Station, and jewelry and golden jewelry of valuing golden jewelry amounting to rupees 1,50,000 was stolen therefrom. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in this said FIR. However, as he was earlier arrested in connection with a similar offense, he has been arrested in the instant case only because of suspicion. Learned counsel for the petitioner has also submitted that the petitioner has already been detained behind the bars for last 27 days, and he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Hathigaon PS case number 86/2024 and has submitted that there are incriminating materials in the case diary against the present petitioner and the co-accused. Who is the co-accused?
Hello?
Who has implicated him?
One Dilbar Ali, then Sajidul Islam.
They are accused.
Yes, madam. Jelhas Ali.
And the
They all are
co-accused
accused.
of this case have implicated him. However, he submits that recovery is there.
Well, that part is not available here, madam. I have not found any note.
So he also submits that the modus operandi of the accused persons involved in the offense is to mold the golden ornament after stealing the same and converting it to and selling the molded form to the unsuspecting customers. Stop. I have considered the submissions made by learned counsel for both the sides and have considered and have also perused the case diary of Hathigaon PS case number 86/2024, which was called for in connection with this case. It appears from the case diary that the investigate that nothing has been recovered from the possession of the present petitioner in connection with this case. And as he has already been detained behind the bars for last 27 days, his further custodial detention under the facts and circumstances of this case does not appear to be necessary if he otherwise cooperates with the investigating officer. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. send back the case diary. This bail application is accordingly disposed of.
I'm deeply obliged, man.
May I please, Your Lordship? 39 application, Your Lordship.
Yes.
Lordship, petitioner is behind the bar 19 days, Lordship. As
How
on
many
that-
days?
19 days.
19.
19, Lordship, as on that 20 days, Lordship. The allegation is, Lordship, under section
Is there is there?
Yes, there is.
379 of faculty, Lordship.
What was stolen?
Scooter.
Lordship,
Bike, bike.
Lordship.
Why have you, why the prayer was rejected by the, whether it was rejected by any other court,
No, Lordship.
magistrate court?
Magistrate court at the time of production, Lordship, we appear directly there.
Bill not filed.
Where is the rejection order?
Registration order, we did not annex, Lordship. That is at CJM, Lordship. CJM at the time of production.
But that has to be annexed. Because there are notifications that all bail rejection order has to be annexed.
Lordship, we did not file it. It is not after perusal of case diary. We did not file at sessions, Lordship, for bail.
No. My query is whether at any stage any bail application was moved.
We did not file, Lordship.
Directly came to High Court.
Lordship, I am not the prime accused in this case, Lordship. The prime accused is Jiban Das, Lordship, who stolen the alleged article, Lordship, and the footage he is recorded is in the CCTV footage also, Lordship. It is
No.
mentioned in the forwarding. And Lordship, my ground of arrest, it is mentioned in the forwarding, Lordship, that I have received some money, Lordship, from miscreant from Bangladesh, Lordship, in exchange of. I am implicated into the case, Lordship, because I am known to prime accused, Lordship, but nothing has been recovered from my possession, Lordship. And as per materials also, Lordship, I am not involved in this particular, Lordship, allegation, Lordship. I have not stolen. Neither I was accompanied. Moreover, Lordship, I have undergone police custody of 3 days, Lordship, and thoroughly interrogated by the investigating agency, Lordship. And thereafter, at the time of re-forwarding, Lordship, that is on page 21, at the time of re-forwarding, that is page 23, Lordship, the investigation agency seek for custodial interrogation of prime accused Jiban Das only. So my custodial interrogation, Lordship, may not be required, Lordship. Therefore, at the time of re-forwarding, they only seek for Jiban Das, prayer for police review. And I have undergone already 3 days of police custody, Lordship.
When were you produced before this CJM?
Lordship, on 31/5, Lordship. That is on page 21, my forwarding report. And I was reproduced on 3/6/24, Lordship.
Yes, Mr.
Yes, Lordship,
Now,
there is
why
a,
have you not approached the magistrate court? Without approaching any court, why have you directly? I fail to understand. Which? Because why have you directly approached the High Court? When easier options were available before you? I just want to know.
Lordship, I approached here because in case of bail, Lordship,
that if you file in CJM or session, then the period of detention until a substantial period of detention, we usually bail prayer is rejected, Lordship.
No, that may not be a good, that
Lordship,
is not a good
I
ground.
understand, Lordship. Lordship is correct.
Unless you approach the magistrate court and try to convince it. Yes.
Yes, here, my lord, this petitioner is not directly connected with the lifting that vehicle, my lord. And moreover, my lord, vehicle, this bike, my lord, bike is not recovered. Bike sold out at Bangladesh, my lord, sent to Bangladesh. And in his account, my lord, 20,000 money was, my lord, sent. By somebody, my lord, that is, here it is mentioned that Google Pay কৰি মোৰ ৱাইফৰ একাউণ্টত 20,000 টকা জমা হয়। সি কয় যে পইচাটো মোৰ মালিকে পঠাইছে আৰু আমিও তেনেকুৱাত বিশ্বাস কৰো।
Yes, Lordship. That is
That
is I have mentioned in my petition also, Lordship, that I received money that I am known to the accused, prime accused, and I just in my account that money has been received.
Not connected with present case, my lord. Earlier, this is December, in the month of December.
No. That much implication is not checked.
This FIR was filed on 23
to February 23.
When the FIR was filed?
23 to when?
Yes.
23 February.
25/5.
And when the money was transferred?
The money was transferred in the month of December 23.
Before this?
Yes. That is the different case, my lord. That main person, Jivan also in his statement said that আগতেও এবাৰ চুৰ কৰা বাইক এটা বিক্ৰী কৰিছিল আৰু সেই টকা বৰ্ণিহাটৰ ধাবা এটাৰ মালিক ভোলা দেৰ একাউণ্টত ট্ৰান্সফাৰ কৰিছিল আগতেও. This is not connected with present case, my lord.
Lordship, I run a dhaba, Lordship, and I know the accused, prime accused of this case, and he asked that someone will send money to your account. That much implication, Lordship. I received the money, even
But
not.
your approach in directly approaching this High Court is not efficient.
Sorry, Lordship.
Because you have to guide your client where to go first. Heard Mr.
K. Thakur, Lordship, on behalf of
K. Thakur, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Olade, who has been detained behind the bars since 3/6/2024 in connection with Gorsuk PS case number 154/2024 under section 379 of the Indian Penal Code. The gist of accusation in this case is that on 25/5/2024, once Adil AADIL, Adil KB, had lodged an FIR before the officer in charge of Gorsuk Police Station, inter alia, alleging that on that day at about 11:30 a.m., his bike within bracket KL 24U bearing registration number KL 24U 6365 was stolen from the parking area of Ayurchandra Hospital. So, learned counsel for the petitioner has submitted that the petitioner is an innocent person and in no way involved in the offense alleged in the FIR. Why you were picked up?
Lordship, I am known to the prime accused and
Who
on
is
his
the prime
request,
accused?
Jivan Das.
It is also submitted that the petitioner was arrested only because he was known, he was an acquaintance of the prime accused, namely Jiban Das. And
And I have received some money on his request in my wife account.
and he had earlier received some money on the request of Jiban Das in the account of his wife. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Gorsuk PS case number 154/2024 and has submitted that the money received in the account of the wife of the present petitioner was
Not connected with present case.
is not connected with the present case, as same was received in the month of
December
December
23.
2023. That is much before the alleged incident had occurred. It is also submitted fairly by the present petitioner that by the learned counsel for the learned additional public prosecutor that presently there is not much material against the present petitioner in the case diary. In view of submissions made by learned counsel for the parties and more particularly the submissions made by learned additional public prosecutor, as well as after perusing the case diary of Gorsuk PS case number 154/2024, it appears that the present petitioner has been arrested in this case mainly on the basis of suspicion, and his further custodial detention is not justified in this case. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamruk Metro and Guwahati, with following conditions, number 1 and number 2. Send back the case diary. With above observation, this bail application is hereby dismissed. Interlocutory application.
It is a lordship. My 439 application, and I was arrested on 6/10/2023 and forwarded to judicial custody on 7/10/2023. My accusation here is that an information was received by the informant that some narcotic substance will be transported, my lord, from Mizoram towards Patharkandi. So, my lord, Naka checking, FIR is a page 12, my lord.
Yes.
So, as per the information, my lord, the vehicle was by registration number TR01BK0613 was supposed to carry, my lord, narcotic drugs from Mizoram towards Patharkandi. Accordingly, my lord, Naka checking was conducted, and during Naka checking, my lord, when the vehicle was intercepted, 500
68 grams of heroin, my lord, was found from the signature chamber. In my
In
case,
the said vehicle.
yes, my lord, from the signature chamber, 568 grams of heroin was found. Lordship will find the same at page 13, my lord, the details. Some 52 soap cases were recovered, plastic soap boxes were recovered from the secret chamber.
Yes.
My case is that I took leave, my lord, in that vehicle. I have explained, my lord, my situation at paragraph 7 of my application, my lord. I took leave in the said vehicle, my lord, while I was coming back to my residence, my lord, and during that time, my lord, I was.
What was the vehicle? What kind of vehicle was that?
Truck, my lord.
Truck. You took leave.
Yes, my lord, I took leave, my lord.
The
But
vehicle was a,
yes, my lord.
what kind of truck? Four-wheeler truck?
Four-wheeler, actually, it was only four-wheeler vehicle is mentioned, man, in the FI. That very first line, man, four-wheeler vehicle.
Four-wheeler, is it a car? Or is it a DI vehicle or?
Yes, my instructions, man, that he only took lift while he was coming back home. He's a
But
day
you
laborer.
took leave, you know in which kind of vehicle you took leave?
Not, properly not taken instructions, man.
Okay. Then
Charge sheet was also laid, man, in this case, and presently the matter is fixed for copies. I'm not arguing, Malad, on the detention period. Only thing is that, Malad, I was not having any conscious position of that.
no, but anybody can take this plea
Yes, sir.
that I took leave. How to differentiate between an innocent person who took, he could have really taken leave and who is impersonating that he had taken leave.
Yes, madam. This point he can fairly raise while framing the charge also, and these are matter of trial also, my lord. And my lord, may kindly peruse page 14. Page 14, my lord.
Yes.
Uh,
What
second
is your
paragraph.
name?
My name is Nomanuddin, madam.
Nomanuddin.
3%.
Nomanuddin.
Second paragraph from below, my lord. They were constantly, my lord, in touch.
Over telephone.
Yes, my lord.
Maybe. Yashuddin was driving the vehicle, Malad. He was in contact. I do not. Taking person.
Next one, I mean. Search it against one.
No, what is the evidence against Nomanuddin?
So far, that portion I have not gone through. There, this
have to
connection
go-
CD, my lord, my lord, they are in
No,
contact.
you find out, is there any connection with Nomanuddin and other
Yes, my lord.
passengers?
Yes, my lord.
Because if he has taken leave, he may not have other connections.
Yes, my lord.
If it is there, he may not be believed.
If it is there, Malad, then certainly my prayer.
And going by this paragraph itself, and it shows they are in touch, my lord.
No, you find out from the statement.
My
I'm fixing it
Day after tomorrow.
day after tomorrow.
Day after, can it be on Monday, my lord?
Day after tomorrow.
Already 2 cases fixed.
Day after tomorrow was short metal.
24. 24.
24.
Friday, if possible, man.
Right, motive already moved cases.
How- We have fixed lot of cases on
Yes, sir.
Friday.
Both fixes at home.
Heard, Mr. M.A. Chaudhary, learned counsel for the petitioner, also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that he needs some time to go through the scanned copy of the case records to find out the incriminating materials available on the in the record against the petitioner Nomanuddin, and thereafter he would make his submission. The prayer is allowed. Let this matter be listed again on 24/6/2020.
Your lordship, my lord, the petitioner applicant, my lord, has been convicted under section 8 of the.
Just take your lordship.
Now, what is your prayer? You will wait for Mr. Deori?
I'll just wait for Mr. Deori. Your lordship?
You may also make submissions.
No, your lordship. My senior would make submissions, your lordship.
But
Well, actually, CD was received earlier and it was returned.
today it is, CD is not there.
Today is not there because it was returned, call for up-to-date CD. So it was received earlier.
Then let us call for the case diary.
Your
Fix
lordship,
it.
I pray that the matter may be taken up after some time, your lordship.
Okay, then within the available time.
Yes, your lordship.
Okay.
Much obliged, your lordship.
Which is your lordship. The last occasion, case diary was called for again, my lord. And I'm an interim, my lord. Petitioners are an interim.
Well, search it subject.
You have appeared.
My lord, that instruction, I was interim, my lord. Direction was to appear before the investigating officer, my lord.
Whether have you appeared or not?
My lord, kindly give some time, I'll take instruction. and
You
in-
take instructions on today itself.
Today I will try, my lord.
Okay.
Yeah, Mr. Dean.
Your lordship, my lord, the petitioner is in interim, my lord. He has appeared before the IO, my lord. On 14/1.
CD appeared.
Heard Mr. M. J. Kadir, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was the petitioner, namely, what is the name?
My lord, Miss Baharul Haq Chaudhary.
Ms. Baharul Haq Chaudhary was granted interim and bail by this court by order dated 4/1/2024, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case record diary of Silchar PS case number 2151/2023 and has submitted that the statement of the petitioner has already been recorded by the investigating officer under section 161 of the Code of Criminal Procedure, Command 1973. Stop. In view of the fact that the petitioner has complied with and has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him by order dated 4/1/2024 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Accordingly, this case is dispersed.
May I please, your lordship? Lordships, in this case,
the entire allegation is against accused number one, my lord. And the petitioner before your lordships are the brothers of the accused number one, my lord. Lordships will find the FIR at page 9, my lord. The allegation is that the petition, accused number one has sold one vehicle, my lord, JCB vehicle, by tempering the number plates and engine numbers and all this, my lord. And in this case, my lord, police has visited the house of the petitioner searching this.
What is your name?
My name is Bilal Choudhury, my lord.
You are accused number 2.
Accused number two, and another brother is there also, Mr. Khabir Ahmed Choudhury. My lord, Umar Farooq Choudhury alias Bilal Ahmed Choudhury, my lord. We are the brothers of the accused number one, my lord.
But Bilal is named in the FIR.
Named in the FIR, no allegation, not a single whisper against him, my lord. It is stated in the FIR that one transaction has been made in the house of the accused number one, that is Khabir Ahmed Choudhury, my lord. This is the only. It is not even stated that the transaction is made in presence of this brother, my lord. Nothing, not a single whisper in this FIR, my lord.
What has happened to accused number 1?
Well, he has been arrested, my lord. He has been arrested subsequently.
He's still
He is in jail, my lord.
okay. Yes.
So far, these petitioners are concerned, my lord. I have not found anything against this petitioner number 2, Kabir Ahmed Choudhury. And this petitioner number 1 is concerned, my lord. He is very much involved in this case, my lord. After police also collected a statement of a garage owner where they have taken those JCB, my lord. And on being suspicious, that owner asking why this engine and chassis number are not there, my lord. They threaten him and that you do your work, we'll do our work, my lord. So his involvement is there, my lord. So for petitioner number 2 is concerned, my lord, there is nothing in the CD.
My lord, in the FIR, the same allegation is against, my lord, accused number 1, my lord. Whatever my learned friend has stated, my lord, these are the allegations against accused number 1, my lord, in the FIR.
No, maybe
My lord.
allegation
And
may be
another
against-
thing is,
Yes,
another thing is that, my lord, the informant who has lost this affair, my lord, he has been arrested by the police, my lord, in another case, my lord. And he suspected that this petition, accused number 1 is involved against his arrest, my lord.
There is no reference regarding that case here because this is different.
That is a different
That's a
story.
No,
different
I have annexed this order case, my lord.
Maybe, but this is a different
Annexure
issue.
B and annexure C, my lord. Wherein the informant was arrested, my lord. Subsequently, after coming out bail,
No,
my lord, he
what
has
the
lost this
accused
affair.
number 1 has stated, whether his statement has been recorded.
Hmm.
The accused number 1,
Obviously, he is denying. He is
he
denying.
has denied.
He is
My
denying. Accused number no, in his statement, he is denying. But the independent witness, the garage owner, where they took the vehicle, my lord, he corroborated this allegation.
There was an agreement between the
Yes, my lord, as per FIR, my lord, that is the accused number 1 has sold one vehicle to the informant, my lord. And that vehicle was tampered with the, as per allegation, that tampered with the number plates and chassis number, all this, my lord. This, whatever my learned friend is submitted in the FIR itself stated that these things has been done by the accused number 1, my lord. And only because of the transaction is made in the house of the brothers of the accused number 1, police is searching, my lord.
where Mr. Kaushik,
My lord,
you flagged those
my lord. I have flagged it already.
statement against the
Yes, ma'am.
heard Mr.
B. Chanda, my lord.
B. Chanda, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Umar Farooq Chaudhry, alias Bilal Ahmad Chaudhry, and Muhammad Kabir Ahmad Chaudhry, who are apprehending their arrest in connection with Hojai PS case number 157/2024 under section 120B/420/468/379/411 of the Indian Penal Code. The gist of accusation in this case is that on 22/5/2024, one Muhammad Jamir Uddin had lodged an FIR against two accused persons, namely Noor Ahmad Chaudhry and Muhammad Bilal Chaudhry, within bracket, present petitioner number 1, inter alia, alleging that the accused number 1 named in the FIR, namely Muhammad Noor Ahmad Chaudhry, showing himself to be the owner of one JCB 3DX bearing registration number AS09 AC 4125, chassis number H001099, engine number 001493903, had executed an agreement for sale of the said vehicle to the informant on 29/2023 at a consideration amount of rupees 11,60,000. And accordingly, the informant had paid the said sum of amount by issuing checks of different amount to the petitioner, to the said Noor Ahmad Chaudhry. However, later on, it came to the light that the said Noor Ahmad Chaudhry was not the actual owner of the vehicle, and he cheated the first informant by effecting a fraudulent transfer of the aforesaid JCB. It is alleged in the FIR that the accused number 1 has misappropriated the said amount of rupees 11,60,000 by resorting to fraudulent means. Stop. Stop. Learned Counsel, on receipt of the said FIR, Hojai PS case number 157/2024 was registered. Learned Counsel for the petitioners has submitted that the accused number 1 named in the FIR, namely Muhammad Noor Ahmad Chaudhry, has already been arrested and he is presently detained behind the bar it is also submitted that the petitioner number one, Mohammed Bilal, petitioner number one, namely Umar Farooq Chaudhry alias Bilal Ahmed, has been roped in the case only because he happens to be the brother of accused number one, whereas brother of accused number one. He has also submitted that in the entire FIR, no allegation has been made against the petitioner number one. Stop. As regards petitioner number two is concerned, namely, as regards petitioner number two, namely Kabir Ahmed Chaudhry is concerned, learned counsel for the petitioner has submitted that there is no allegation made against him in the FIR and he is innocent. It is also submitted by learned counsel for the petitioner that the petitioners are ready to cooperate in the investigation. However, they are apprehending arrest in this case as police is searching for them. On the other hand, learned additional public prosecutor has produced the case diary of Ojai PS case number 157/2024 and has submitted that though there is no incriminating material in the case diary against Mohammed Kabir Ahmed Chaudhry, that is the petitioner number two. However, there are implicating materials against the petitioner number one, namely Umar Farooq Chaudhry alias Bilal Ahmed, as independent witnesses have deposed that the JCB in question was taken to the garage by the accused number one along with the present petitioner.
Worship, I'll take leave. I have to attend court 20 minutes.
I'm allowing them to appear before. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Ojai PS case number 157/2024. As no material is presently available against the petitioner number two, namely Kabir Ahmed Chaudhry, his application for anticipatory bail may be allowed. This court is of considered opinion that his application for anticipatory bail may be allowed. As regards petitioner number one is concerned, though there are incriminating material against the said petitioner in the case diary, however, considering the fact that the main accused, namely Noor Ahmed Chaudhry, has already been detained behind the bars, and also considering the progress made in the investigation, the custodial detention of Bilal Chaudhry, that is the petitioner number one, does not appear to be necessary if he operates in the investigation. In view of above, both the above named accused persons, both the above named petitioners, namely Umar Farooq Chaudhry, alias Bilal Ahmed Chaudhry, and Kabir Ahmed Chaudhry, are hereby directed to appear before the investigating officer of Ojai PS case number 157/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so, within the stipulated period of time, comma, in the event of their arrest in connection with Hojai PS case number 157/2024. They shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. Send back the case diary. This anticipated bail application is accordingly disposed.
Biplab.
And back.
No.
I'm praying for a date, your lordship, a short date 37, because the case there will be necessary.
Heard Mr. T. Devi, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that the case diary has not arrived and prays for some more time for producing the case diary. When will you produce?
So, Bosisto, my lord,
The prayer is allowed. Let this case
25.
be listed on
25.
25 4.
6.
25/6.
Yes, Bosisto, my
25/6,
local.
2024.
That I
For case diary.
Biplab.
Search it submitted.
Yes, they have appeared, but immediately they have appeared after obtaining this.
Heard Mr. M. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated
13/12/2023
by this court, and in pursuant to the directions of this court, the above named petitioner Namdev, above petitioners have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned additional public prosecutor has submitted that in the meanwhile, charge sheet has already been laid, bearing charge sheet number
436/23, dated 23/12/23.
in view of the submissions, in view of the fact of the laying of charge sheet, as well as in view of the submissions made by learned counsel for the petitioner, the interim bail granted to the above named petitioners is hereby made absolute. This anticipatory bail is accordingly disposed of.
Deeply applied.
Lordship, I beg indulgence regarding item number 16, Lordship. In this case, Lordship, appellant is a juvenile, Lordship. He was convicted under 302 and punishment for 3 years, Lordship. That appeal was, that conviction was upheld by the appellate court, Lordship. Now this revision has come up, Lordship. Now, Lordship, IA is for, Lordship, bail is there, Lordship. May I pray, Lordship, let this matter be taken up on Friday, Lordship, because 3 years is there, Lordship.
No, Friday we are already. The leftover registry will decide the dates. If there is any urgent, extreme urgency, then court master will give dates.
This is
Because
because Lordship, already Lordship, that conviction order was upheld by the appellate court.
That is all right now.
That's why
Time, question of time.
it permit Lordship on Friday, Lordship.
not on, you 25th.
Highly obvious. Only 47 and 49, I have on my request, it has listed. So next week, any date can be done. 56 or
The court master will give them.
Lordship, item number 43, Lordship. In item number 43, there is interim, Lordship. That may be continued, Lordship.
Interim, wherever there is.
Yes, Lordship, we have received the CD, Lordship. CD received, Lordship.
Short date, give a short date.
My lord, item number 52 kindly fix a date, my lord. Only my lord, condonation of delay petition was filed, my lord.
When do you want?
My lord, day after tomorrow or
On Tuesday.
Tuesday, my lord.
Tuesday.
It's the legal service for he is in jail on the condonation of delay
Okay,
petition.
Tuesday.
2050.